From
May I
the
mention loss? I 250 list loss. Item number 49.
Why do you need to mention now?
No, this is the first appeal loss, additional metal loss.
अभी सेकंड हाफ का बेंच अलग है।
Please, go ahead.
पहले ये बताइए जो आज फिक्स किया हुआ वो करेंगे कि नहीं? उसकी पहले
हम तो तैयार हैं, इसमें कोई एक मर गया
वो
है।
हम नहीं जानते।
इस पंद्रह
वो
में
तैयार है लेकिन कोई मर गया है, ये इसका क्या मतलब?
जब तक वो डिलीट नहीं होता कैसे?
From the supplementary list, under heading for first filing, item 1BA 3876 of 2026.
Serial 32. Which all are the matters? Only serial 32?
32 and 33.
This is 1 plus 32 plus 33, right?
Yes, 32, 33.
We wait.
Item 2, BA 3928 of 2026.
This where is the petition?
For the offence under section 103 का सब clause 140 का 1 and 238 का the DNS code. That is the matter.
Mr. Absent, question.
From the daily list, under heading for orders, item 1, BA 2651 of 2026.
Orders waiting.
आइए
आइए, let us start.
Section 316 clause 2, 318 clause 2 of the DNS Act, 406 and 420 of the IPC. Both sections are confoundable in nature. The matter has been compromised, and as for allegation, my candidate is here the allegation, page 14.
Who's for the informant?
Your Lordship, I am.
You are compromised?
Yes, Your Lordship.
I have filed a counter affidavit, Lordship.
Yes.
There are 3 criminal incidents, Lordship, and para 153 and the petitioner has been identified by the informant and the defense witness in the
You take care of this in the trial. But so far as for bail is concerned, we can close. What the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that primarily the case arises out of money transaction between the parties. It submits that the parties have settled their dispute outside the court, and consequently, IA number 6306 of 26 has been filed jointly by the petitioner and the
Partner and informant.
informant का क्या नाम है?
Informant.
Petitioner and the informant. The learned counsel for the petitioner has further submitted that the petitioner is in custody since
Since my Lord, 16/12/2020.
16/12/2025
2025.
and charge sheet has already been submitted. The learned counsel for the state has opposed the prayer and has submitted that the petitioner also has criminal activities.
identified as para
And he has also been identified and there
para
is
153 of the case.
there is sufficient material on record against the petitioner. Correct?
Petitioner and the defense witness has been identified.
And the petitioner was also identified.
And petitioner has a criminal incident.
Two.
There are 3 criminal incidents. The 2 criminals or 1? 3 cases involved.
जिसमें अपोज करना आता है उसमें तो चुप रहते हैं. ये कॉम्प्रोमाइज हो गया है, मनी ट्रांजैक्शन में खड़े होकर अपोज करें. Criminal antecedent लिखिएगा. Sufficient material on record to link the petitioner with the alleged offence. The petitioner has also been identified. Right? After hearing the learned counsel for the part, the counsel for the informant is present. He has submitted that the matter has been settled outside court and the petitioner and the informant has no objection if the petitioner is released on bail. After hearing the learned counsel for the parties and considering the appropriate submissions and also the custody of the petitioner is to be released on bail. Are you closed?
Undertaking for fresh filing. Item 2, VA 3492 of 2026.
Section 65(1) of DNS 2023 under section 46 of POSCO Act, allegation involves the promise of marriage when he established physical relations. इसमें है कि घटना 66 और
पढ़िए FIR. नाम मत पढ़िए.
दिन शुक्रवार करीब 3 बजे दिन में अपना खेत में मेरी बेटी और
नाम नहीं देना.
उम्र करीब 14 वर्ष जलावन की लकड़ी इकट्ठा करी थी. उसी बीच विश्वनाथ
नाम नहीं दीजिए.
पिता सोनसो अयोध्या के रहने वाले मेरी बेटी को भगा कर ले गए शादी का झांसा देकर तथा वो अपनी बहन सोनसो यहाँ ले गए तथा मेरी बेटी सोनसो के साथ शारीरिक संबंध बनाया. दिनांक 8/6/2025 को करीब 11 बजे रात को सोनसो मेरी बेटी को वापस घर पहुंचा दिया गया तथा मैं और मेरी बेटी पूछताछ करने लगी तो सोनसो की चचेरी बहन सोनसो मेरे साथ मारपीट करने लगी.
आपको क्या बोलना?
इसमें कि 66 को ये घटना हुआ लेकिन FIR 9 को दर्ज हुआ और कुछ भी ये फोर्स का कुछ भी ऐसा एलिगेशन नहीं लगा.
The girl is a minor, 14 years of age. तो क्या होगा बताइए? क्या स्टेज है बताइए?
स्टेज की
कस्टडी कब से ये बताइए?
ये 10/6/2025.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that though the petitioner is named in the FIR, but there is no allegation of forceful sexual intercourse with the victim. And the petitioner is in custody since 10/6/2025. The learned counsel for the state has opposed the prayer and has submitted that the petitioner was only 14 years of, the victim was only 14 years of age. And the petitioner is a major, aged 21 years. And considering the direct allegation against the petitioner, he may not be enlarged on bail. He has also submitted that as per the interim order, the victim has fully supported the prosecution case. And to this, the learned counsel, after hearing the counsel for the parties and considering the direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the petitioner is in custody since 10/6/2025. And certainly the trial is required to be expedited. The learned counsel for the state is directed to ensure that the witnesses are promptly produced before the court. The Council for the State is directed to communicate this order to the Director of Prosecution and also to the Superintendent of Police of the concerned district.
Item 3, BA 3500 of 2026.
टू 861 में बेल दिए हैं
सब बेसिक में पता है तीनों केस में मिलेगा
ऑर्डर अपलोड हो गया
यस इज द फोर
कोई एंटीसिडेंट
कोई एंटीसिडेंट नहीं है इवन स्पेसिफाइड और
यस व्हाट डू यू
yes
से
similar
Heard the learned counsel secretary on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 29/1/2026 and has no criminal antecedent. He has further submitted that victim identified.
no victim
No victim has
been already given that many
No victim has been identified. He has then referred to the order passed by this court in DA number 2861 of 2026, DA number 3161 of 2026, and DA number 3308 of 2026, whereby bail has been granted to the accused, namely Ajay Kevat, Rakesh Kumar, Nitish Kumar Mandal, respectively, by orders dated 30/4/2026. Service that the case of the petitioner is similarly placed. The learned counsel for the state has opposed the prayer, however, the approaches submissions made by the counsel for the petitioner has not been disputed. After hearing the learned counsel for the parties and considering the fact that similarly situated co-accused persons have already been enlarged on bail, the petitioner is directed to be enlarged.
Item 4, BA 3725 of 2026.
Counsel for the petitioner seeks permission to withdraw this petition. Accordingly, this petition is dismissed.
Sign sir. Item 5, BA 3833 of 2026.
This is number section 17296 BNS and it post. Sorry, boy and the girls are members in love relationship members and boy is 19 years
Age.
old. Boy is
Age
19
of
years old and the girl is 17.3 years old. And
From where you say that there was love relationship between the couple?
this one is from the result of the FIR itself reflects on this.
Let's read it.
Yes. Page 18 members, the complaints. Surname.
Page 18, just.
FIR
पढ़ी.
Surname कहना है कि मैं सत्यन सच, एज सत्यन सच, सिमरिया का रहने वाला हूँ. दिनांक इतना करीब 10 बजे मेरी पत्नी द्वारा फोन आया कि मेरी बेटी जिसका नाम सत्यन सच है, डॉक्टर ऑफ सत्यन सच, एज 17 ईयर है, वो मेरे गांव का लड़का जिसका नाम सूरज कुमार पिता सत्यन सच है, गांव सत्यन सच है, एज 19 ईयर, जो मेरी बेटी के घर के शादी के लिए भाड़ा कर ले गया है. मेरी बेटी का मोबाइल नंबर इतना है जो पिछले कुछ महीनों से लगातार बात कर रहे थे. कुछ छानबीन करने पर अभी तक मेरी बेटी को पता नहीं चला. मुझे घर की मेरी बेटी के साथ कोई नहीं हुआ. This finder has been lost after 6 days matters of the incident. And no other matters.
There is a statement of the victim, 183.
Charge sheet has been filed actually. I am informed that charge sheet has been filed. And moreover, matter this boy is behind the custody for nearly 1 month.
क्या करना है?
statement of the क्या मुझे
इसी में लिखा हुआ गाँव का लड़का भगा के ले गया. आप क्या बोलेंगे? इसी में लिखा. कस्टडी कब से रखा है?
After 1st of May 25.
1 For the learned counsel opinion on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since one. Petitioner aged 19 years is in custody since 1/2021. And as per the allegation, the victim was 17 years 3 months
Yes.
on the date of occurrence. He submits that as per the FIR itself, it is alleged that petitioner had taken away the victim with a view to marry her. He submits that the petitioner and the victim belongs to the same village. And there is delay of 6 days in filing the FIR. The girl has already been recovered.
Yes.
Girl has already been recovered.
Yes, yes, yes.
The learned counsel for the petition submits that on the face of the FIR, it is apparent that it is a case of love relation between the parties who are in adolescence age. The learned counsel for the state has opposed the prayer of law and has submitted that the victim was a minor. After hearing the learned counsel for the parties and considering the allegations made in the FIR itself, as stated by the learned counsel for the petitioner, and also the custody of the petitioner since 1/2025, the petitioner is adequately to enlarged on bail. If condition is satisfied, the petitioner shall not disturb the victim in any manner also.
Under heading for admission, item 6, BA 111822 of 2025. Item 7, BA 1111 of 2026.
Therefore, regular the petitioner in custody in the criminal case since
183 plus
3/11/2025. The case is registered under 109 and 126 of the BNS, and it has been alleged that the informant engaged a photo and was going towards the memo. In the meantime, petitioner has tried to molest her and has also shot. This is the case, and in the meantime, some villagers are nearby camp. There are
183, the statement of the victim.
it has been called for by
It is there.
Yes.
इसमें वो स्टेटमेंट दी है कि मैंने उसको कुछ गलत नहीं कर दिया है। देखिए, दिखाई सकते हैं। ये स्टेटमेंट लास्ट सेंटेंस। देखिए ना, मैंने उसको कुछ गलत नहीं करने दिया। कस्टडी बताइए।
Study है Gama 3/11/2025.
Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner has submitted that as per the allegation, the petitioner had tried to molest the victim However, he has submitted that the statement of the victim recorded under section 183 BNSS has been called false from the motion and it is available on the The learned counsel has submitted that though the victim has suffered certain injuries, but simple injury, which are simple in nature, but she has herself stated in her statement under section 183 BNSS that the petitioner tried to the petitioner threatened the victim to commit rape, but he could not do so, as the victim did not permit him to do it, did not allow him to do it. The learned counsel for the state has opposed the prayer and has submitted that that the victim has supported the prosecution case so far as the attempt to commit rape is concerned. Though fortunately, the petitioner could not commit rape, as per the statement recorded under section 183 BNSS. It is not in dispute that the injury suffered by the victim is simple in nature. After hearing the learned counsel for the party, to this the counsel for the petitioner has submitted that the petitioner has no criminal antecedent.
He has not had no criminal but acquitted, para 16 no criminal act.
Though of same nature.
नहीं 379 का acquittal है दोनों केस में किसका था
दोनों में कहाँ लिखा
para 16
The learned counsel for the petitioner has submitted that though there were 2 cases registered against the petitioner under section 414 and 379 IPC, but the petitioner has been acquitted in both cases. And certainly the cases are not of the nature as is involved in the press release. Charge sheet has been submitted. When? The learned counsel submits that the charge sheet has already been submitted. After hearing the learned counsel for the parties and considering the statement of the victim recorded under section 183 BNSS, where it appears that there was an attempt made by the petitioner to commit rape. The petitioner is addicted and the custody of the petitioner, charge sheet having been submitted, the petitioner is addicted to be enlarged on bail. A condition रहेगा, the petitioner will not disturb the victim in any manner.
Item 8, DA 1498 of 2026.
On the previous date of hearing, that is 15/4/2026, order number 4, this honorable court has directed the state to file a counter affidavit to bring on record the FSL report of the mobile and also to bring on record in seal cover the statement of the victim. However, we have not received any copy of the counter. One more time.
कब रख दें? Next Thursday. Next Thursday रख दें. DA number 1498 of 2026. The learned counsel for the
163 statement, 183 statement.
The learned counsel for the FSL का क्या सिचुएशन?
देख लगता है लेटर भेजे आया नहीं,
The learned counsel for the state prays for and
दोनों कोटीज है,
नहीं आप वहाँ FSL तो जाएगा कोर्ट में तब ना कोर्ट से आएगा,
देख
इसलिए वो आप ही को मंगाना
हम
है।
पता कर लेते हैं।
The learned counsel for the state prays for and is granted 1 week time to file the counter affidavit. Office is directed to call for the statement of the victim recorded under section 183 BNSS from the concerned court. Post this case on next Friday. Let this order be immediately communicated to the court concerned.
If the stage of trial is also called for, because I think
Along with the stage of the case.
Item 9 DA.06.05.2026.
Office registered under section 108 of the DSA, corresponding section 306 of the Constitution, abatement of suicide.
Who are you?
First January case 13 minutes. It is alleged that informant's daughter was having love affair with this petitioner had gone to his house. From there, it was
Read it, please. Read the FIR.
मेरा नाम जेठो सिंह 40 वर्ष निवासी ये परीक्षा सिंह ग्राम कमलेश्वरा थाना रंका जिला गढ़वा के निवासी आज दिनांक 18/11/2025 को समय करीब 11:28 बजे रंका थाना पुलिस पदाधिकारी के समक्ष ग्राम गासेदाग में बिना किसी भय दबाव या प्रलोभन के अपनी स्वेच्छा से बयान दे रहा हूँ कि मेरी बेटी सीता कुमारी उम्र 18 वर्ष पिता जेठो सिंह शाकिर तमगे थाना रंका जिला गढ़वा करीब 2 वर्ष से अरुण सिंह पिता मिथिलेश सिंह उम्र करीब 20 वर्ष साकिब गासेदाग थाना रंका जिला गढ़वा से प्रेम संपर्क तथा दिनांक 17/11/2025 को मेरी लड़की सीता कुमारी अरुण सिंह के घर ग्राम गासेदाग में जहां मेरी बेटी सीता कुमारी को ग्रामीणों के द्वारा तथा जनप्रतिनिधियों के द्वारा समझाया गया कि लड़का पहले से शादीशुदा है, यही समझा बुझाकर मेरी बेटी सीता कुमारी को ग्राम गासेदाग से मेरे घर दमगे के जनप्रतिनिधियों तथा ग्रामीणों के द्वारा पहुँचा दिया। इसके बाद रात्रि में खाना पीना खाकर सभी लोग सो गए। जब सुबह जगे तो पता चला कि मेरी बेटी ग्राम गासेदाग अरुण के घर के पास पीपल के पेड़ में फांसी से लटकी। सूचना पाकर जब हम गासेदाग गए तो देखे कि मेरी बेटी पीपल के पेड़ में फांसी से लटकी। मुझे पूर्ण विश्वास है कि मेरी बेटी सीता कुमारी प्रेम प्रसंग के कारण क्या There is no instigation, mallards, no abatement, no misdemeanor, mallards. कहीं कुछ नहीं है, ये भी बल्कि समझा बुझा रहा था कि आप उनकी शादी करो, यही केवल लव अफेयर है that has come और she was adamant to marry with this petitioner.
क्या बोल रहे हैं?
plus in the statement of confessional statement of the accused,
Confession statement of
he has admitted that he was in love affair with the deceased, and subsequently he has married. Subsequent to this deceased was willing to marry the accused, and subsequently she committed suicide. So no, there is a
लव अफेयर है, नो क्राइम।
no.
मैरी कर दिया किसी और से, नो क्राइम। अबेटमेंट क्या है?
Plus because she was adamant to marry the.
एडमिट टू मैरी कैसे शादी कर लेते?
Because there was because of the mentality that she was.
सेकंड मैरिज तो हो नहीं सकता है ना? Yes, these are the circumstances. They were having some affair. Ultimately, the boy did not marry. He married somebody else, and she was adamant to marry him. Out of depression, he has done it.
Plus he
आप
himself
admit
has
कर सकते हैं।
stated that he was in love affair with the.
आप
deceased.
conviction कराइए 1200. For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that on the face of FIR, it is apparent that the victim had love affair with the petitioner, and when the petitioner married somebody else, there was a panchayat also, and ultimately the victim went back home, and on the next day she was found hanging, and she committed suicide. The learned counsel submits that the case has been registered under section कौन सा BNS?
108.
108 of BNS is charge sheet submitted.
Yes.
And the charge sheet has also been submitted under the same section. That means that the petitioner could not have married the victim as he had already solemnized marriage, and there is no abatement so far as the petitioner is concerned. Abatement of committing suicide so far as the petitioner is concerned. The learned counsel for the informant has opposed the prayer and has submitted that since the petitioner did not marry the victim, he committed suicide, and therefore case is finally. To this, counsel for the petitioner has submitted that petitioner is in custody since
19/11/2025.
19/11/2025. Charge sheet has already been submitted. Counsel for the state has opposed the prayer for bail and has supported the submissions made by the learned counsel for the state. After hearing the learned counsel for the parties and the aforesaid submissions made by the learned counsel for the petitioner based on the FIR itself, and considering the fact that the charge sheet has already been submitted and petitioner is in custody since 19/11/2025, the petitioner is directed to go. Yes, what condition do you want? The petitioner shall not disturb the informant and his family members.
Item 10 DA.06.05.2026.
32%. सीरियल नंबर कितना है ये सीरियल नंबर कितना है? 10.
ऐसे सेम PS केस का नहीं है, लेकिन जामताड़ा PS का ही केस है।
कोई बात नहीं।
हाउ दे आर सबमिटिंग द रिपोर्ट, उसको कुछ डिस्क्लोज करेगा।
ठीक।
Item 11 DA.0464/2026.
FIR करें। FIR
करीब 36 देवर के रहने वाले दिनांक इतना को समय देख करीब 3 बजे
एक पेज नंबर बताइए प्लीज थोड़ा सा। हाँ बताइए।
मेरी बेटी करीब 17 वर्ष पिता भवेश चंद्र झा ट्यूशन पढ़ने के लिए घर चली थी। शाम को करीब 5:30 बजे तक जब मेरी बेटी ट्यूशन पढ़कर वापस नहीं आई, घर में अगल बगल के पूरे ग्राम अपनी बेटी का पता लगा, लेकिन कहीं नहीं मिला। तब उनके सगे संबंधी को फ़ोन करके अपनी बेटी का पता लगाया, लेकिन कुछ पता नहीं चला। अपने स्तर से खोजबीन करने के क्रम में शाम के करीब 7:30 बजे शिवम झा उम्र करीब 20 वर्ष पिता प्रदीप झा वर्तमान पानीपत दिल्ली जो रिश्ते में विक्टिम का मामा का साला है, जो बराबर से फ़ोन से बात करती थी। फ़ोन करने पर बताया कि विक्टिम का खोजबीन करना छोड़ दीजिए। कारण में विशाल पांडे उम्र करीब उम्र करीब 24 वर्ष पिता अशोक पांडे तथा बजरंगी शर्मा उम्र करीब 26 वर्ष पिता रवि शर्मा, दोनों का साकिब बस स्टैंड शर्मा थाना शर्मा जिला देवघर, तीनों मिलकर शादी करने के नियत से शर्मा से भागकर ले आए हैं। उस वक्त तीनों व्यक्ति हसडिया में रहने का बात बताया। रात को करीब 9 बजे शिवम झा हसडिया से पुनः फोन करके बताया कि विशाल पांडे और बजरंगी शर्मा दोनों मिलकर उसके साथ मजबूत करके शादी करने के नियत से वहाँ से भाग गया। उसमें यह भी बताया कि दोनों मामलों के साथ साक्ष्य बना सकते हैं। शिवम झा has love affair with the victim.
Victim कहाँ?
Victim तो मालूम 164 के स्टेटमेंट is not alleged anything against me और
Where is the statement?
और जो annexure 2 को देखिए
Statement कॉल फॉर हुआ है अभी तक?
annexure 2 को देख लिया बंधु annexure 2 को जो शिवम झा बजरंगी शर्मा उसको बेल हो गया 32 को।
और शादी किससे करना था उसको?
शिवम झा से और शिवम झा फिर कहते हैं कि नहीं हमको मारपीट किया था।
विक्टिम का स्टेटमेंट 183 का कहाँ है?
उसका स्टेटमेंट 183 का स्टेटमेंट नहीं आया है उसमें। एक इनका लेक्चर 2 में ये बात आई हुई है कि 183 में स्टेटमेंट पेज 70 में आया फ्रॉम कंक्लूजन ऑफ द विक्टिम का रिकॉर्डेड अंडर सेक्शन 183 बीएनएस इट appears that there is no needless any fact on the part of either of these।
कहाँ पे है वो?
ये पारा से पेज 70
इम्प्यून ऑर्डर।
नहीं जो उनको बेल हुआ है शिवम झा एंड बजरंगी शर्मा। शिवम झा ही जो है उनको शिवम झा के नाम पे
ऑर्डर नंबर 3 है, इसमें तो केस डायरी नहीं आया। ऑर्डर नंबर 3 है, केस डायरी नहीं आया।
हम ये दिखा रहे हैं लेक्चर 2
183 का स्टेटमेंट के बिना आपको बिल नहीं दे सकते। I call for the statement on office is directed to call for the statement of the victim recorded under section 183 BNSS from the concerned court. Let this order be communicated to fact post this case on next along with her medical examination report. Medical examination report तो होगा इसमें? ठीक है, 183 का स्टेटमेंट हो जाएगा along with the medical examination report from the concerned court, right? Post this case on 15th. Communicate through fax. 15 तारीख।
Item 12 DA.06.05.2026 along with item 13.
Cases have been tried together, but because both of them are arising out of the same FIR. But the case of mine was heard by the Honorable Court and my submission has been encapsulated by the lawsuit order number 3, order dated 18/4/2026 in Umesh Mahto's case. But I am not named in the FIR, so it's a case of gang rape. And I was not put to TIP. I have read the case study right from paragraph number 1 to 204. I was not put to TIP. I have never been identified by the victim. And counter affidavit.
This is the same story with both the cases.
Same.
Never identified, never.
I was not put to TIP. And only on the basis of confessional statement of the co-accused, the name of these two petitioners have surfaced. This has been also admitted in paragraph number 6 of the counter affidavit.
Yes, madam, what is there against the petitioner?
Confessional statement of court Manoj Puran Masran Kumar Mehta, Brother Suresh Mehta, is that he was present at the place of occurrence when the rape was being committed, and he has assisted in the commission of crime. That is it. The girl has.
He did not commit rape.
No. As per the confessional statement, he was present, but he did not participate.
About same दोनों का तो खड़े थे ये लोग दोनों।
Umesh Mehta was present.
Where is the confessional statement of one of them?
Yes, confessional statement of co-accused and
सोनू महतो किसका पढ़े बताइए?
Para 65 minutes. Para 65 minutes.
Para 74.
74 minutes.
I'll read it myself.
Yes, yes.
क्या नाम है petitioners का दोनों?
Umesh Mahto and petitioner number 2 is Tulsidas Mahto.
उमेश महतो and तुलसीदास महतो। heard the learned counsel appearing on behalf of the parties. Are you named accused?
No, not named in here.
The learned counsel for the petitioner submits that the petitioner is not named in the FIR, and the name of the petitioner has come in the confession statement of co-accused. The petitioner has not even been put under TIP, and accordingly has not been identified by the police. He submits that even as per the statement of the co-accused, the petitioner had not committed any rape upon the victim. Rather, as per the statement of the accused, the petitioner had participated in taking away the victim.
Yes.
He submits that the statement of the accused, mere statement of the accused, may not be a reason to detain the petitioner. The learning counsel for the state, though has opposed the prayer, however, the aforesaid submissions made by the petitioner is not investigated. ये बताइए antecedent.
No, I have also stated in
Upon
the
inquiry of this court, the learned counsel for the state has stated that the petitioner has not been antecedent. To this, counsel for the petitioner submits that the petitioner is in custody since
Got custody since 14/10/2025 para 7.
14/10/2025 and charge framed.
Charge has been framed on 3/2/2026, but no witness has been
Charge has been framed on
3/2/2026.
3/26, but no witness has been turned out so far. After hearing the learned counsel for the parties and considering the aforesaid submissions and apparently accept confession statement of the accused, nothing could be pointed out by the state against the petitioner, and the petitioner does not have any criminal antecedent. The charge having already been framed, the petitioner is directed to be involved on bail. A condition: the petitioner shall not disturb the victim / her family member in any manner. दोनों का अलग अलग ऑर्डर ड्रॉ करेंगे लेकिन सेम रिजल्ट.
Item 14 DA2704 of 2026 along with item 15 and 16.
cheating, cheating in dishonesty in using delivery property. 316 criminal breach of trust. 361 criminal professionals along with some sections of ITI. In case of prosecution was commercial by customer is receiving an information by using a mobile. UPI related fraud has been committed at Vijayanagar, Karnataka.
Where is the case diary?
They find pornographic fraud.
What is there against the petitioner? Let's see this one. BA number 2704. Kundan Kumar and
Kundan.
there are two persons.
Yes, ma'am. From the person of Kundan Kumar, 2 mobile and 3 SIM has been recovered.
Just a moment. Petitioner number 1.
Kundan.
2 mobile,
2 mobile, 3 SIM.
3 SIM. In name of other persons.
In his name, not having no connection with prosecution history.
And any victim? Any victim?
Right now, we have filed contract with him. On subsequent development of the investigation, one victim has come who said that from said mobile number, which has not been recovered from the possession of these petitioners, 2,100 rupees, and from another 25,000 rupees.
Custody?
Custody loss, I am in custody loss since January loss. 2nd of January 26, charges have been submitted loss, charges have been claimed.
126, charge sheet submitted.
Charges have been also been claimed loss.
Charge claimed.
Petitioner has got no criminal action, so I have stated even loss in their contract with the it is also.
Is that correct? Whatever he has stated.
इनका victim नहीं है।
Victim नहीं है? Heard the
What
learned.
are other two petitioners?
We'll see that. Heard the learned counsel stating on behalf of the parties. The learned counsel for the petition submits that he is in custody since 2/1/2026, having no criminal antecedent, and charge has already been framed. He has further submitted that as per the allegation, 2 mobile and 3 SIM have been recovered from the possession of the petitioner, but no victim could be connected with the petition. The learned counsel for the state has opposed the pair. However, the opposite submissions made by the counsel for the petitioner is not been decided. Considering the fact that the charge sheet has already been submitted and the petitioner has no criminal antecedent, the petitioner is directed to bring down. Next, the pen. This one, 2781. Custody.
Custody loss, same date loss from
2/1/26.
2/1/26.
Charge framed.
Charge framed.
Antecedent.
No antecedent loss.
No antecedent. Recovery.
Recovery loss, the mobile number which was being traced by the police in the Vijayanagar Karnataka case, that has been recovered from his police. It's a mobile number.
There is Vijayanagar PS case.
अब विजयनगर में होते एक मामला दर्ज हुआ, उसको इंटरसेप्ट
इंस्टीट्यूट हुआ ना केस.
यस यस
विजयनगर
यस यस
कर्नाटक. उसमें आपका बेल हो गया? उसमें आपको रिमांड मिल गया?
उसमें इन्वेस्टिगेशन में कुछ लेके नहीं आया. एज येट नथिंग हैज कम इन द इन्वेस्टिगेशन कि whether Karnataka police has asked for remand or not.
हाँ बताइए.
और इन्वेस्टिगेशन में आया भी नहीं है. बस टू दैट एक्सटेंट.
इसके अलावा कोई है लिंक? इसके अलावा
इनके पास विक्टिम है और सिर्फ एक विक्टिम है.
वो भी विजयनगर वाला. एक विक्टिम विजयनगर वाला.
मधुबन उत्तर प्रदेश का है.
मधुबन
चौरसिया और इतना चौरसिया सारा शिकारी कोल थाना मधुबन जिला मऊ उत्तर प्रदेश.
FIR इंस्टीट्यूट.
FIR के बारे में डिस्क्राइब नहीं है, लेकिन during investigation it has been found that from the mobile seized from this petitioner it is used in victimizing the victim.
और ये विजयनगर वाला FIR
विजयनगर वाला दूसरे केस के साथ है, वो है नेक्स्ट जो केस है उसके साथ है.
इनके साथ नहीं.
इसके साथ
ये BA नंबर 2781 में नहीं है ये विजयनगर वाला.
विजयनगर वाले में है.
नहीं थोड़ा क्लियर रहिए क्योंकि ये तो विजयनगर की कहानी सुना.
विजयनगर वाला जो केस हुआ है वो जो मोबाइल सिम पाया गया है मनोज कुमार के पास.
एक के साथ मिक्स मत करिए प्लीज. डोंट मिक्स इट.
वही फाउंडेशन है इंटायर प्रोसिक्यूशन केस का.
What is the case? One complaint of cyber fraud laws that in name of sex services somebody doing the cyber. That is law in the Karnataka. And that mobile is running in the Hazaribagh area. On the basis of that feedback, police on the basis of tower location intercepted one car. And from that car, these 5 persons are arrested. In such, several mobile SIMs, etc. were found from them, and mobiles contains the advertisement of those sex services as complained in the Karnataka. सारे मोबाइल में पाए गए कि लोग कैसे उस पे एडवर्टाइजमेंट किए और अपना मोबाइल नंबर को डाले हुए हैं और उस
advertisement relating to some sex traffic.
सेक्स जो कंप्लेन किया गया था वो मोबाइल भी पाया गया. उस कार में जो बैठे हुए थे मनु कुमार अदर उसके पास से वो एलियंस मोबाइल पाया गया. एक फर्दर इन्वेस्टिगेशन फाउंड दैट अनदर मोबाइल आल्सो इज इन
आपको बेटी दे.
नहीं इसमें जो बताया पेज नंबर 24 पे एट वेरी फर्स्ट इंस्टेंस आई हैव ऑलरेडी सबमिटेड कि द नंबर व्हिच हैज बीन ट्रेस्ड बाय द पुलिस दैट हैज बीन रिकवर्ड फ्रॉम प्रेजेंट ऑफ दिस.
काफी है. काफी.
इन्वेस्टिगेशन हैज बीन कंप्लीटेड. charge sheet has been submitted petitioner having no criminal antecedents.
क्रिमिनल एंटीसीडेंट तो हो ही गया, एक विजयनगर में केस इंस्टीट्यूट हो गया और उसके बाद एक और विक्टिम हो गया काम काफी।
मैटर ऑफ विक्टिम इज कंसर्न विजयनगर का भी जो
देखिए हम बहुत लिबरली बेल देते हैं, दैट इज नॉट अ केस BA number 2781 of 2026. Some fees at this stage you can buy 5 bail application every day. BA number 2781 of 2026. Heard the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 2/1/2026 and charge has already been paid. And there is no criminal antecedent of the petitioner. We have submitted that one case was instituted in Vijayanagar, Karnataka, and where it was found that the mobile involved in this case was involved. The mobile seized was involved, and ultimately the petitioner was arrested. The learned counsel for the state has opposed the prayer and has submitted that the matter relates to committing cyber crime in the name of sex services, and naked photographs of girls were uploaded in the website to the mobile. The learned counsel submits that on the basis of the information received, raid was conducted and the petitioner was apprehended. Considering the nature of allegation against the petitioners and the link which has been found during investigation, this court is not inclined to enlarge the petitioner on being dismissed. ये सुमित वर्मा, इनका क्या?
नेक्स्ट मनु कुमार, इसका भी सिमिलर।
मनु कुमार का तो हो गया, मनु कुमार
has already decided on this, right?
हाँ, अभी मनु कुमार हम डिसाइड करते हैं।
अभी वो जो
सुमित कुमार तो कुंदन का किया।
देखिए पहला कुंदन का अलाउ कर दिए, कुंदन का अलाउ किए, अलाउ किए, मनु कुमार का रिजेक्ट किया। अभी हम रिजेक्ट किए BA नंबर 2781 ऑफ 26, ठीक है। अब ये बताइए
ये सुमित भी सेम है, इसमें भी वन विक्टिम।
नहीं, इसका कर्नाटका वाला केस और इस रैकेट से क्या लिंक है?
कर्नाटका वाला जो केस लॉन्च किया गया, वो मोबाइल नंबर जो उसमें यूज किया गया, दैट मोबाइल रिकवर्ड फ्रॉम दिस।
From whom?
From this Sumit.
No.
That is been recovered from Manu Kumar.
मनु कुमार
दूसरा सिम पाया गया जिसमें विक्टिम।
इनका जो प्रोसिक्यूशन का केस है कि एक मोबाइल नंबर को ट्रैक कर रहे थे, दैट वाज रिकवर्ड फ्रॉम द प्रेजेंस ऑफ मनु कुमार।
मनु कुमार, ये नहीं, सुमित कुमार के पास दूसरा सिम पाया गया, सॉरी, सुमित कुमार के पास एक सेकंड सिम पाया गया जिससे वन विक्टिम,
व्हिच इज नॉट देयर इन एफआईआर।
उसके अगेंस्ट में तो फिर केस नहीं है। विक्टिम क्या है? हु इज द विक्टिम?
one victim has stated that he see the aid and thereafter called on the mobile,
ये कहते हैं
which is mentioned in
कौन सा
that
पैराग्राफ में केस डायरी है आपके पास?
is that he has
इसका विक्टिम का दिखाइए।
para 36
लाइए or the learning council appealing on behalf of the parties. The learning council for the petitioner has submitted that the petitioner has no criminal antecedent and he is in custody since 6 months.
20th of January, 2nd of January, 26.
2/1/2026 and charge has already been paid. The learned counsel for the state has opposed and has submitted that there is no victim. The learned counsel for the state has opposed the prayer and has submitted that the matter arises out of running out of allegation of running a well-organized online fraud by operating websites in the name of escort services and in paragraph 36, a victim has been found linked with the petitioner, which relates to petitioner number 1 and 2 के साथ
टू के पास
petitioner number 1, which on the basis of which the sex services were found to have been provided. So far as the petitioner number 2 is concerned, the learned counsel submits that no victim as such has been identified. After hearing the learned counsel for the parties and considering the serious allegation and the victim having been identified, so far as the petition number 1 is concerned, this court is not inclined to enlarge the petition number 1 only. However, since no victim has been identified with respect to petition number 2 having no criminal antecedent, please direct it to be enlarged. ये थोड़ा केस डायरी में करेक्शन में थोड़ा सा देखना
15 पास में 15 को पास में
1 का रिजेक्ट 2 का अलाउ
Item 17, DA.06 of 2026.
State of the case.
स्टेटस रिपोर्ट स्टेटस रिपोर्ट तो नहीं आया स्टेटस रिपोर्ट नहीं आया स्टेटस नहीं मंगा रही 183 एंटीसीडेंट ये सब नहीं आया FIR पड़ी FIR Are you named in the FIR?
Page number 48.
नाम नहीं पढ़ेंगे प्लीज एज कितना है विक्टिम का as per school record no
The time of admission was 69.
69 how
In between 16 to 17.
in between 16 to 17
That is in page 126 of the diary. स्कूल सर्टिफिकेट का 24/11/2008 आईडी Aadhaar card also that this this
just a moment आप उसको लेके भी चले गए 4 दिन तक रख के एज पर द स्टेटमेंट पढ़ी 183 कहानी लिखी heard the learned counsel separating on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and the victim was around 17 to 18 years of age. The learned counsel has further submitted that the petitioner is in custody since 11/10/2020 and charge sheet has already been submitted. Any antecedent?
No antecedent.
He submits that the petitioner has been given an antecedent. The learned counsel for the state has opposed the prayer and has submitted that the age, as per the school records, the age of the victim was between 16 to 17 years. And the petitioner has committed rape upon the victim at her residence. The statement of the victim has been received, recorded under section 183 BNSS has been received from the concerned court. And upon perusal of the statement, this court finds that there is direct allegation against the petitioner, and accordingly this court is not inclined to enlarge the petitioner on the question.
Item 18 BA 3033 of 2026.
Initially, the FIR was under 103, but subsequently charge sheet has been submitted on 108 that is abetment to suicide. In marriages of 2011, 14 years exactly after marriage, the girl commits suicide. The allegation of demand of dowry notes relates to year 2016. When it is alleged that the father of the victim had passed the retired, then a demand of 22 lakhs was made. Thereafter, there is no emergence in such allegation. Admittedly, I was not at home when she committed suicide. That is a case of suicide. Now, since the occurrence is 14 years after the marriage, there is no presumption attached to marriage. There were 2 children who are known as without parents. I am in custody, and the mother obviously has passed away.
Custody since?
I am in custody now since June 2025, 30th June 2025.
Is there any suicide note?
Yes, there is no suicide note. But the father nurse who has been examined has said that the suicide note is in the diary itself.
Father has been examined.
Yes, father has been examined, and
From
in his
where
examination,
From where do I see this?
that person has not been filed, but the father has been examined. Sorry.
How many witnesses are there?
Because my latest instructions are that out of 39 have been examined. 2 of them have been examined day before yesterday.
Out of 39 have
9 have been, the relatives have been examined. The father has not supported, he has been declared hostile, infirm, and declared hostile.
We'll expedite your time.
That's the only issue. The children are absolutely.
We'll expedite it. What is the next date? You tell us now. What is the next date?
Just. Because I have cooperated with the child, I have not delayed the child. It's a very experienced child. So you should consider that I will appear each and every day. The children are suffering.
Only 4 witnesses, only official witnesses. Can't you produce the official witnesses? देखिए अभी हाँ बोलिए. हर डेट में every date witness will be produced. It's such a material fact. अगर आप बताएंगे तो next date में भी witness आएगा.
हाँ वो हो जाएगा. The only reasonable time for my defense की जरूरत होता है.
वो आपका जो है.
I will expedite. And if the prosecution does not complete, then I'll come.
Certainly you can come. Then I'll put the prosecution on top.
So then I don't have an order, Your Lordship, and then allow me to withdraw. Because Your Lordships are, I don't want to find you on merits that I am the husband, etc. It happens even if the bail orders do prejudice at times. 2nd June. proceeded second.
After some arguments, when this court was not inclined to enlarge the petitioner on bail at this stage, the learned counsel for the petitioner seeks permission to withdraw this application. Accordingly, this petition is dismissed as withdrawn.
The report was
At this stage.
direction only because you are also inclined to direct the prosecution. That's the
However, he has submitted that out of 13 witnesses, 9 witnesses have already been examined. The learned counsel, the state is directed to ensure that the remaining witnesses are promptly produced. Counsel for the state is directed to communicate this order to the superintendent of police of the concerned district and also to the director of prosecution. To this, the counsel for the petitioner has also submitted that the next date in the trial is 2nd of June, which has been taken note of the counsel for the officer.
साइन कर दीजिए. Item 19 DA.06 of 2026.
Case of murder. The wife was, there is allegation that wife has been killed by the husband. The fire is at page 15.
Slit her masticamus. I'll explain. What is this date?
It's 9, I have no idea about, there are 9 charges.
The impugned order is dated 13/10/25.
They say no witness, but I suppose there are some witnesses that have been
You have any idea? Witnesses have been examined? करवा देंगे. आप ही का काम है, सरकार आप ही. कस्टडी बताएं.
18/5/2025. वो एंटीसिडेंट बताओ.
चार्ज फ्रेम हो गया.
चार्ज फ्रेम कर.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and he is in custody since 18/5/2025. The charge has already been framed. The learned counsel for the state has opposed a prayer for bail and submits that there is direct allegation against the petitioner that he slitted the neck of his wife by knife and committed her murder. After hearing the counsel for the parties and considering the direct allegation made against the petitioner,
3 witnesses.
to this the counsel for the petition submits that 3 out of 9 witnesses have already been examined.
Next date is 18/5/2026.
After hearing the learned counsel for the parties, this court is not inclined to enlarge the petition on bail in view of direct allegation against the petitioner. However, there can be no reason for non-production of the remaining for expeditious production of the remaining witnesses and also the FSL report. The learned counsel for the state. The state is directed to ensure prompt production of witnesses and also to produce the FSL report before the court concerned. The counsel for the state is directed to communicate this order to the superintendent of police of the concerned district, FSL Ranchi, and also to the director of prosecution. Counter affidavit by during the course of hearing is taken.
Item 20 DA.3100 of 2026.
काउंटर का डायरेक्शन हुआ था, रिसीव कर लिया, काउंटर फाइल लेकर 1 वीक मोर टाइम.
at the request of
So one criminal incident है ये रियल का है ये हम लोग we have given that.
antecedent में हम cyber offense में देंगे. Repeat.
उनका कंप्लेंट है जो है
Council for the state prays for 1 week time to file the contract report. सबको accused का bail भी rejected.
सबका बिल 5 लोग का बिल.
अच्छा ठीक है.
आज मन लीगल कॉम्प्लेक्स फार्मर.
Sorry.
लीगल रिकवरी है that is related to his father here we wanted.
आप बेटा दोनों का बिल हो जाएगा तो दोनों जने मिल के फिर से यही काम करेंगे.
नहीं हम वही सोच रहे हैं. I was thinking about that issue कि पहले ये सोशल सिस्टम में क्या चेंज आया है.
अब फैमिली बिजनेस हो गया.
कि कम से कम पहले होता था कि नहीं बात.
Post on next Friday.
उस पे हम I have any scope.
फैमिली बिजनेस हो गया.
वही हम सोच रहे
इसलिए
हैं.
इसलिए नौकरी की जरूरत. अभिजीत सिंह लिखिए अपीयरेंस.
Item 21 BA 3130/2026.
Offense under 396 of the Business Act corresponding to 354 items. As per the FIR, the age of the victim can be disclosed by the informant 17 years. But the admission card, date of birth is 2008, 17/10/5. The statement of victim was recorded under section 180 of the Business Act and 183 statement was also by law.
हैदराबाद लेके गए. रिकवर कहाँ से हुई?
Recovered to Goda sir. We are permitted to place on the statement.
एज बताइए विक्टिम.
ये जो है 17 वर्ष 10 महीना का.
और पिटिशनर का एज?
पिटिशनर का एज जो है 20 years. एज ए डिफेंस में ये अभिनेता निशा कुमारी ये दिया गया जहाँ निशा को बताया कि मेरा नाम निशा कुमारी है. हम अपने नाबालिग
धीरे धीरे पढ़िए. नाम मत पढ़िए.
वहाँ सूरज कुमार दास से मुलाकात हुई.
अरे नाम मत पढ़िए.
उनको बोला कि चलो गोटा चलो दिखाते हैं.
कहाँ से पढ़े थे?
180 गोटा चलो मेला दिखाते हैं. ये चली गई पता नहीं सूरज वाला को क्या खिला गया. गोटा से जसीडी से ट्रेन से दिनांक 2/2/2026 को हैदराबाद में किराए पर रूम लेकर दोनों एक रूम में दोस्त की तरह. हम लोग संबंध नहीं बनाए कि इसी में सूरज कुमार दास घर वालों के
क्या बोलना आपको?
पता चला.
कस्टडी कब से?
कस्टडी जो है हम 10/2/2026.
10/2/26. चार्जशीट हो गया?
चार्जशीट.
नो एंटीसीडेंट.
नो एंटीसीडेंट.
चार्ज फ्रेम हुआ? नहीं बना. क्या बोलना है आपको? रिस्पोंडेंट विक्टिम का एज बताइए.
अपना स्टेटमेंट में अपना उम्र बता रही है 15 साल.
उनका स्टेटमेंट का कितना वैल्यू है?
180 का इन्वेस्टमेंट मेरा 15 साल.
आपको नहीं पता? इन्वेस्टिगेटिंग अथॉरिटी.
हाँ वो आया है.
कितना आया?
17 साल.
17 साल. असली चीज तो बताई ही नहीं. और the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 10 to 2026, having no criminal antecedent, and charge sheet has already been submitted. We have submitted that as per the victim herself, as per the FIR, the victim was allured by the petitioner and was taken to Hyderabad. However, he submits that in a statement under section 180 BNSS, he has stated that they were living as friends in Hyderabad for a few days, and ultimately she came back to Godda. Yes. When they came to know about the case, the learned counsel for the state has opposed the prayer. However, the aforesaid submissions are not in dispute. Upon a query of this court, he has submitted that it has come during investigation that the victim was 17 years, 10 months of age. The statement of the victim, recorded under section 183 BNSS, has also been perused by this court, and it appears that she has simply made a statement that she was allured by the petitioner and taken to Hyderabad, and as of now, she does not want to stay with the petitioner. No further allegation has been made. Considering the aforesaid facts and circumstances and the fact that charge sheet has already been submitted, the petitioner is in custody since 10 to 2026. The petitioner is directed to bring up. The petitioner shall not disturb the victim or his family members.
Item 22, DA 3134 of 2026.
In this case, the FIR was registered under section 64 also, apart from the other sections. But after investigation, the police submitted charge sheet barring section 64.
64 is what?
64 is there. No, that is not, charge sheet has not been filed.
183 statement is filed.
No, you can see 183 not the charge sheet which has been submitted under section 4 section only corresponding board. 323, 341, 420, 506, that is 115/2, 126/2, 318/4, 351/3. These are the 4 sections for which charge sheet has been submitted. Apart from section 67, 67A, 64(1) of the Information Technology Act, IT Act. Now the allegation is not.
रुक जाइए पहले 183 का स्टेटमेंट के बिना कुछ समझ में नहीं आया. इनका ये वीडियो सीज हुआ है. Tell me, video has been seized. Both are major. They had some affair.
Yes.
On pretext of marriage lawsuit की है already earlier.
इसीलिए 64 में चार्ज शीट नहीं हुआ, 376 में चार्ज शीट नहीं हुआ, बाकी हुआ और सब गलत हुआ. 323, 341.
Video has been seized or not? ये केस डायरी है, देखो आपके पास होगा केस डायरी. नहीं
सीज हुआ. Para 25.
इन्होंने वायरल किया है क्या वीडियो? ऐसा कोई एलिगेशन? Was this video made viral?
Yes, viral of several witnesses stated that he sent the mobile SIM video in mobile and thereafter.
From where do I see? Where do I find it?
$25 million CCS.
वीडियो भी बनाए वायरल भी किए, इसका क्या करें?
Kindly see, for that purpose, not the section 67 and 67A of the Information Technology Act is also there. Charge sheet has been submitted. He is in custody since 23rd November 2025.
और prescribed punishment कितना?
200 maximum sentence of 3 years. 67A. I clear. Subject to consent by so far, the allegation not physical relation is concerned not that has been disbelieved by the police in course of investigation. Charge sheet has not been submitted in under section 64. That is the so far the viral part is concerned. It is alleged in the FIR itself that in September 2025, petitioner took her to a hotel and took snaps.
First offense में 5 साल and second offense में
First offense of 5 साल. 3 years of first offense.
and 67B.
67B नहीं है, 67A.
चार्ज किसने फ्रेम किया?
67 चार्ज नहीं हुआ, चार्ज शीट.
चार्ज शीट किसने?
67 and 67A. 67A वही तो 3 साल.
5 साल.
67B में है.
67A में भी 5 साल. First offense.
A में 5 years. First conviction shall be punished on first conviction with imprisonment either restriction for a term extend to 5 years or with fine which may extend to 10 years.
Custody कब से बनता है?
Custody में मुझे 23/11/23 23rd November.
Heard the learned counsel subpoena on behalf of the parties. The learned counsel for the
No
petitioner
antecedent
submits that the
that is
petitioner is in
counted
custody
with
since
so-
29/11/2025, having no criminal antecedent, and charge sheet has already been submitted. He has submitted that no charge sheet has been submitted under section
64 of the
64
BNS.
of BNS, and the charge sheet has been submitted under section 67 and 67A of the Information Technology Act. और कोई section नहीं है?
बाकी BNS का मिल रहा है.
But
1152 115
and a few section under
BNS.
BNS. Their punishment prescribed and the maximum punishment for the alleged offence is 5 years under section 67, as the present offence is the first offence as per the prosecution.
There is no antecedent.
No antecedent?
They have submitted the report. Annexure B. Annexure A.
The learned counsel further submits that, as per the allegation itself, the petitioner and the victim were major, and they entered into consensual relationship in the context of marriage. It is alleged that the counsel for the state has opposed the prayer. However, their forged submissions are not in dispute. However, he has further submitted that the video was also made viral by the petitioner. After hearing the learned counsel for the parties and considering the fact that the petitioner has no criminal antecedents and he is in custody since 23/11/2025. The petitioner is addicted to the environment.
Item 23 DA 3136 of 2026.
Page number? Read please.
लगभग 10-12 वर्ष पूर्व मेरी बेटी सनी परवीन का विवाह राजू अंसारी जिला झारखंड के साथ मुस्लिम रीति रिवाज से हुआ था, जिसके 2 बच्चे हुए। दोनों के बीच सब कुछ ठीक ठाक चल रहा था। मेरे दामाद राजू अंसारी पेशे से सिविल कंस्ट्रक्शन की ठेकेदारी करते हैं, जिसका पिछले 2 साल से किसी लड़की के साथ प्रेम संप्रसारण का मामला चल रहा है। यह बात मेरी बेटी सनी परवीन ने हम लोगों को बताया। इस वजह से मेरी बेटी के साथ मेरे दामाद राजू अंसारी तथा उसके माँ बाप मेरी बेटी के साथ हमेशा मारपीट और प्रताड़ित करने लगे। इस संबंध में मैंने अपने दामाद को बहुत समझाया बुझाया, उसके माँ बाप से भी बात की, लेकिन उसकी माँ का कहना है कि आपकी बेटी से अपने बेटी की शादी करवाकर हमने गलत किया, क्योंकि आपकी बेटी मेरे बेटे के लायक नहीं। अब मेरा बेटा जो चाहेगा अपनी मर्जी से करेगा, यदि आप लोग करता है तो अपनी बेटी को अपने घर ले जाएगा और दामाद राजू अंसारी मेरी बेटी के साथ हमेशा मारपीट करेंगे।
Who is the petitioner?
Petitioner is that she is alleged to have an illicit relationship with the accused.
President of the disease.
Yes. She has not been named in the FIR also. And other co-accused person, that is mother-in-law and father-in-law of the deceased, have already granted bail.
सारा कहानी का जड़ तो आप ही है।
अच्छा, but nowhere it has been proved that.
क्या है क्या against?
The same confessional statement and also दोनों admitted हैं कि that they are in.
Only confession statement. There is no recovery. Are you sure?
Confessional statement here. अब बाकी सब का वही है statement कि ये बाकी सब other witnesses have also stated that both are relations.
Thirty-one 10/25 का impugned order है. 5 witnesses out of 10 were already examined. What is the present stage of the case?
It is at the stage of evidence.
How many witnesses are left to be examined?
As it is fixed on 18th May.
How many witnesses are left to be examined?
As per the impugned order, 5 witnesses have been examined.
Impugned order कितना महीना पुराना? How many witnesses are to be examined? Current status नहीं पता.
Current status is still evidence.
If 1 or 2 witnesses are left, we will not release you on bail on that ground. If the trial is in the facts end, we don't release you.
Then I see an adjournment to 1 week. I will find out that how many witnesses are left to be examined.
(201) क्यों लगा है? From where were the body recovered? Body was recovered from where?
पुल के पास से, रोड के पास से.
Which paragraph is the confession statement of the petitioner?
Thirty-six, 26 and 36.
Yes.
This is the statement of the husband. वहाँ पहुँचने पर अंधेरा हो चुका था। जैसे रेलवे ब्रिज के नीचे से अंदर गुजरा, सुनसान जगह पाकर मैं जानबूझकर अपनी मोटरसाइकिल को गिरा दिया, जिससे मेरी दीदी मिसेस को रोड में बगल में झाड़ के पास गिर गई। मौका पाकर उसके मुंह दबा के काले रंग का हिजाब से जोर से दबा दिया। 10 मिनट
The petitioner was also there with him. No. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 13/11/2023. And there is allegation against the petitioner that she, in connivance with the husband of the victim, the husband of the victim connived with the petitioner to kill his wife, the victim. Yeah.
No, in the FIR, it is only mentioned that because she was having, her husband was having illicit relationship with this petitioner, on mere suspicion, it is assumed that because of this illicit relationship, he along with his mother and father has killed this.
The learned counsel for the petitioner submits that as per the FIR, the husband of the victim was having illicit relationship with the petitioner, and ultimately the husband and her in-laws killed her. She submits that apart from confession statement, there is nothing against the petitioner. The counsel for the state has opposed a prayer and has submitted that the name of the petitioner has transpired in the confession statement of the husband of the victim, and ultimately the confession statement of the petitioner has also been recorded. And as per the confession statement of the husband of the victim, the husband killed the victim. To this, counsel for the petitioner has submitted that custody लिख दिए ना 13/11/2023. After hearing the learned counsel for the parties and considering the allegation as against the petitioner, and that the name of the petitioner has come only in the confession statement of the accused, the petitioner is directed to be enlarged.
Item 24, DA 3142 of 2026.
This is an application for grant of regularly under section 85 of BNS, that is not the 498A, section 109 BNS, that is not 307, section 118, that is 324 IPC, 351-2506 IPC, 352 equivalent to 504 IPC. But the petition is not named in the After revision of the FIR, one will find that there was not the dispute between the husband and the wife.
Are you the husband?
Pardon?
Who are you?
Well, I am nowhere. I am not be related to them. But the only the evidence that has been brought forward by the prosecution that the confessional statement my name has come.
No, how are you related to the family in a case
No,
under
Madam,
Section
I have-
498A?
Madam, the informant say that the husband there was the cases, series of cases pending. When she was returning along with her brother, two unknown persons had chased on motorcycle. One of them has fired upon her. And she said that injury was not the guns of injury was found on the face and not on the back side. But the doctor has examined her. Doctor has not found any injury on the face. No blood, the greatest injury has been found. Only blood, the simple injury has been found by the doctor. Blood, apart from that.
By gun?
Gun. Blood, the
Gunshot, simple injury.
simple injury, that is what he said, the doctor said now. 1 centimeter into 1 centimeter, that is not the epilepsy. That has not been recovered. So, Lord, I have got no concern with Lord the firing.
Gunshot, simple injury.
Yes.
One simple injury.
Simple. Then, Lord, the so far.
Do you have any antecedent?
No. I have stated, I am not the ward parcel. Lord, at paragraph 15, Lord, I have stated, supporting with the document also, madam.
No antecedent?
No accident, madam. The long Lord the fire that Lord the says about Lord the involvement of Lord the husband and Lord the vessel, etc. Only thing Lord,
So allegation is that somebody killed her,
somebody
tried
killed
to kill
her. I
her
don't know. This is clear.
at the instance of the husband and the family members.
And when two unknown persons, she says that she could not identify.
Yes.
क्या
क्या मिला है इनके अगेंस्ट में? सुपारी की इसीलिए एंटीसीडेंट क्योंकि एंटीसीडेंट है क्या?
एंटीसीडेंट तो नहीं होगा।
सुपारी दे दी।
इनका गवर्नमेंट का जो भैंसों थे सुपारी दिए थे 2 लाख की, जिसको मार के बहुत केस उस करती है।
तो वो ठीक है, हमको समझ में आ रहा है, लेकिन इनके अगेंस्ट में क्या पाए कन्फेशन स्टेटमेंट के अलावा?
अब इनका मोटरसाइकिल क्राइम में हुआ है, वो भी कवर हुआ है।
कैसे पता इन्हीं का मोटरसाइकिल?
हाँ आया है।
बट कैसे आया?
सीसीटीवी फुटेज से आया है।
शॉर्ट करते हुए पकाया है।
सारा एरर देखते हैं।
पैरा 11 बताइए।
तो आदमी के पीछे जांच कर रही है, मोटरसाइकिल SP 125 डीलक्स वाहन मालिक आरिफ जो पिटिशनर है और जो
उल्लेखनीय कि गोड्डा बाजार स्थित शालीमार होटल, यही है ना? पढ़िए आधा मत पढ़िए।
उल्लेखनीय गोड्डा बाजार स्थित शालीमार होटल एवं मिठाई दुकान लगे सीसीटीवी फुटेज का अवलोकन पाया कि घटना के दिन 17/1/26 को होटल दुकान के लगे सीसीटीवी 3:57 में अपराह्न में 1:57 बजे बीच में सबसे पहले बागी पीड़िता की मोटरसाइकिल भाई के साथ तथा उसके पीछे एक नीला रंग का नीला नंबर का अपाची मोटरसाइकिल, जिस पर 2 व्यक्ति सवार थे, पीछे एक काला रंग का जिस पर 2 व्यक्ति सवार होकर सामने सड़क पार की। शालीमार होटल में दुकान लगे सीसीटीवी कैमरा
इतना ही कैप्चर हुआ है कि मोटरसाइकिल गुजरा, उसके अलावा तो कुछ कैप्चर नहीं।
109 में है कि मतलब पिटिशनर का जो सुपारी दिया उसके बीच में बातचीत हुआ है, टेलीफोन की आया है।
सुपारी का बातचीत भी आप रिकॉर्ड करते हैं?
हाँ, इस पर आया है।
कहाँ?
बताइए। सीरिया में
पैरा नंबर
109
बात हुआ तो बात तो किसी से भी सीखा होगा। सुपारी का बात हुआ, ये कहाँ से बोल रहे हैं?
फायर की बात नहीं कर रहा हूँ, बात की लोग सुन होता टेलीफोनिक कन्वर्सेशन हुआ है जिसका सीरिया
बड़ा मुश्किल आज के दिन में फोन पे बात करना। कस्टडी बताइएगा आपसे।
जो कस्टडी है 21 से 26 पैराग्राफ
चार्जशीट नहीं हुआ अभी तक?
नहीं हो गया, चार्जशीट हो गया।
चार्ज फ्रेम?
नहीं चार्जशीट खाली हुआ है और हमारा कोई इतना एक्सीडेंट नहीं है।
About the council's appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is in custody since 21/1/2026, and as per the FIR, there was matrimonial discord between the husband and wife, and there were further litigation between the two, and it has been alleged that the family member had hired persons to kill the victim. However, she could escape as only simple injury was found by way of gunshot. The learned counsel submits that the petitioner does not belong to the family and he has not been named in the FIR. However, he has been made accused primarily on the basis of confession statement of co-accused and also his confession statement. And also his confession statement. The learned counsel submits that the petitioner does not have any criminal antecedent. The counsel for the state has opposed the prayer and has submitted that apart from the confession statement, as per the CCTV footage, the vehicle of the petitioner was crossing by the victim while she was moving with her brother. He has referred to paragraph 11 of the case diary. However, from perusal of para 11 of the case diary, apart from this aspect of the matter, there is nothing to show that petitioner shot any gunfire or assaulted the victim. Then the counsel for the state has referred to para 109 of the case diary to submit that there was conversation amongst the family member of the victim and the petitioner. A family member of the informant and the petitioner. After hearing the learned counsel for the parties and considering the fact that the petitioner has been made accused on suspicion and on the basis of confession statement, the petitioner is addicted to the enlargement bill, having no antecedent.
Item 25 BA 3144 of 2026.
काउंटर का डायरेक्शन था काउंटर डायरी आ गया डायरी से अलाउ किया था 15 criminal enforcement.
Yes, sir. There is one way earlier litigation was indicated. I am aware of the fact. I had also argued for some time before this honorable court. If you lordship will have a look to page 20, which is Annex 1, that is the earlier order passed by this honorable.
Yes. What is the case circumstances?
Now, after going through the entire case, as it will be a wastage of valuable time of the court to repeat the facts of the case. The fact remains that I alleged to have cheated a sum of 33 lakhs from the person. The victim is not coming forward. However, I am not entering into the matter. I had advised my client if he is ready to deposit the entire amount
before the trial court in the form of draft with a condition subject to the result of the case and with a condition that he will be attending the court. Now,
Sir,
so far the antecedents are concerned.
such kind of conditions we cannot put. Because even if after the trial, suppose you are acquitted or convicted, this money cannot be adjusted.
Victim or
Even
decided by the trial court.
no, if you are even if you are convicted, this money cannot be given to the victim.
No, yes, that is what I am saying.
So it is of no use. And repeatedly we are getting orders of the Honorable Supreme Court that such kind of securities and such kind of conditions are not.
In big cases, Supreme Court has
No, even in small cases.
Exactly.
Practically, you see, deposit of money is of no use. Because it cannot go to the victim under any circumstances unless fine is imposed.
But while disposing of my petition, my Lord, my earnest prayer to this Honorable Court is that let this offer be indicated in the
I will certainly.
Supposing my party tries his luck.
Yes, he may.
This fact ought to be there in the Hindu law. You may justify by judicial order that this deposit will not serve any purpose. That is what your also
because this is
that offer ought to be there.
That's heard the learned counsel secretary on behalf of the parties. The bail application of the petitioner was earlier rejected in BA number 1686 of 2026 by order dated 12/3/2026. The learned counsel submits that on that day, after some argument when this court was not inclined to enlarge the petition on bail, the petitioner sought permission for withdrawal of the bail application. The learned counsel has submitted that though the petitioner has as many as 15 criminal antecedents.
In most of them he has been acquitted, in some of them he is on bail. अगर इतना पैसा वो बोल रहा देंगे तो सब में वो यदि जेल में रहता तो कहाँ देता? Understand?
The learned counsel submits that in some of the cases he has been acquitted and in some he has been granted bail.
This is the only case in which he is in custody.
And has further submitted that this is the only case in which the petitioner is in custody. The learned counsel for the state has opposed the prayer and has submitted that there is an allegation of fraudulent withdrawal. Withdrawal है ये?
नहीं, ट्रांसफर किए थे ये मोबाइल हैक करके उनको मोबाइल कॉल किए थे और मोबाइल कॉल किए कि मेरी बच्ची बीमार है इस बात में अकाउंट.
Okay. The learned counsel submits that it's a case of cyber crime wherein through mobile communications, a sum of rupees 33 lakhs has been defrauded. To this, the learned counsel for the petitioner has submitted that the petitioner is ready to deposit rupees 33 lakhs by way of demand draft as a condition of bail, and
subject to the
result of the case, and as a condition of bail, and undertakes to cooperate with the trial.
Cooperate with the trial since the charge has been framed.
And charge has already been framed.
These notices have been sent for appearance of the witnesses.
After hearing the learned counsel for the parties and considering the fact that the bail application that earlier when this court was not inclined to enlarge the petition on bail, the bail application of the petitioner was rejected by the order dated, was withdrawn by the order dated 12/3/2026. The petitioner has numerous criminal cases against him, and there is direct allegation against the petitioner of committing cyber fraud. So far as the argument of the petitioner to deposit rupees 33 lakhs as a condition of bail is concerned, this court is of the view that such deposit will not serve any purpose, as even if the petitioner is convicted, the amount cannot be attested. Cannot be attested against the amount cannot be attested.
It will go to the victim.
कैसे विक्टिम को कैसे जाएगा?
Victim या state would be decided by the trial.
Such this court is not inclined to enlarge the petitioner upon the offer being given by the petitioner. Accordingly, this bail application is hereby.
Item 26, DA 3146 of 2026.
Offence under section 26 offence against 31/8/25 को और FIR और 9/25 को 8 दिन में
ऑफेंस कब का है? ऑफेंस कब का है?
ऑफेंस का लॉसिंग 21/8/2025 से 1/9/2025 और FIR और 9/9/2025 आफ्टर 8 days.
Delay of 8 days.
They permitted to be FIR.
Yes, please.
Please see page number 1. victim का एज है लॉसिंग 47 और हमारा एज है 90 प्लस। सबने निवेदन है कि जिला लाते हैं कि लॉसिंग में अपने बच्चों को पढ़ाने के लिए विजय प्रसाद के घर में किराए कागज रोला घरों में रहती हूँ। दिनांक 31/8/25 को समय करीब 6 बजे समय में घरों से व्यवहार मिलने जा रहे थे। स्कूल चौथा के पास पहुंचे वहाँ पहले समझिए नाम पिता रंगा और राम बढ़िया पी रहा था। मुझे देखकर रंजित बोला आइए बैठिए भाभी। आगे में बैठकर बातचीत करने लगा। रंजित राम का बेल बातचीत करने लगे। कुछ देर बाद रंजित खाना पीने लगा क्योंकि मेरा एक दिन पहले ही इलाज करवाए थे इसलिए मैं पीने से बाहर का इनकार करने रंजित को जान पूछ कर मुझे गिलास आने दूसरे दिन बोला कि आज कर पी लीजिए। पीने के दौरान रंजित ऐसा मैंने सुना पिता
आप you are not named in that fire.
Yes, I am
Not named. You read it. आगे पढ़िए.
पीने के बाद मैं बेसुध हो गया नहीं चल उतरा पढ़ी रेडियो अगले दिन दिनांक 1/9/2025 को सुबह 7 बजे जब मैं नींद खुला तो मेरे चाचा से तो बेरा उन्होंने बताया कि प्रभात ने उनको चौथरा के पास इस हाँ की प्रकृति और बेहूदी उसी हालत में मिली और मुझे कहते हैं बोले कि इसके कहने पर उस हालत में क्यों तब मैं अपने ससुर को सारी बात बताई। मेरा बेटा रोनी की बताया कि आपको घरों से निकलवा दोनों भाई बहन को मिठाई खाने के लिए पैसा देकर रंजित चल रोज की उस समय आपके पास रंजित चर्चा करवा दूसरे को नाम बनेगा और दिनेश राम मौजूद था। जब मेरा पुत्र लोग तुरंत ही लौट गया दोनों को रंजित राम के साथ खाना खाने की बात करते हो खाना युवक चला गया। कुछ देर बाद मेरा बेटा मुझे चित्रा के पास पहुंचा तो मुझे वहाँ नहीं देखने पर होते हैं अगल बगल खोजने लगा। खोजते बगल में
आपका नाम कहाँ से आता है?
आपका फेसबुक रिस्ट्रिक्ट कोई
जब पढ़ते हैं वहाँ पे नाम चढ़ाए जब मेरा बच्चा लोग तुरंत ही लौट गया तो लोगों को रंजीत राम because the present petitioner
रंजीत राम is not the present petitioner. रोहित राम का नाम
रोहित राम his name is come in the confession
काउंटर में फाइल किया कहाँ लिखे हैं? Nothing more.
3 persons she has taken that they have committed.
बेल किसका हो? बेल किसका हो?
रंजित
Where is the bail order?
जिस पर स्टूडेंट है लॉ से अभी इंटरमीडिएट में नाम नहीं होता है उसका मैट्रिक
उसका जो है पास है उसका
Heard the learned counsel appearing on behalf of the parties.
Charge convicts of the
Charge Premukha. The learned counsel for the petition submits that he is in custody since
custody since last month.
10/9/2025. The victim is 37 years of age and who is also the informant of the case, and the petitioner is 19 years of age. They have submitted that there is delay of 8 days in filing the FIR and the petitioner is not named in the FIR. They have submitted that there is specific allegation against Ranjit Udaon, Joseph Udaon, Dinesh Udaon and Anu Udaon, as mentioned in the FIR itself, but no allegation has been made against the petitioner. And he is also not named. He submits that the name of the petitioner has come only in the confession statement of the accused, and there is no other material against the petitioner. The learned counsel for the state, though has opposed the prayer for bail, but their forced submissions are not in dispute. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, and also the fact that charge sheet has already been submitted, the petition is, and the accused named in the FIR, namely Ranjit Udaon, has already been enlarged on bail. The petitioner is eligible for that.
Item 27, DA.06.05.2026.
Just a moment. Not named, no antecedent,
and mercy. Islam that in this case only on the basis of mercenary assassination, simply because the victim stayed at home one night.
What is the age of the victim?
16 years. And entire CD Lursi, petition है मैंने taken the victim from her house. इसमें आया हुआ है जो Lursi. काउंटर में है victim का statement from the
petitioner is a lady.
Lursi.
इनका क्या रोल?
इनका वही है कि 1 लाख मेरे घर में रुपया आई, हमको मेरे पास जो विजय रखा था, मेरे पास लाके इस लड़की को मैंने ही फोन दिया, जो वो घर में है मेरे ही लिए है, मेरे ही फोन से उसको वो अपने घर में कॉल की, अपने बॉयफ्रेंड को कॉल की, इसमें आया हुआ है।
एक सेकंड,
मेरा नाम
just क्या बोलना आपको? इनके घर में रुकी है बस इतना ही।
1 नाइट रुकी है, वहीं से रिकवरी हुई है। देर फोन भी दी है, फोन दी है बात करने के लिए, हाँ पेरेंट्स से बात करने के लिए पुलिस आई है। और
BA number 3160 of 2026. और the learned counsels, आपका कोई antecedent नहीं है ना? Or the learned counsels appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is not named in the FIR and has no criminal antecedent. The petitioner is in custody since
received 15/12/2025.
15/12/2025, and charge has been framed. Charge has already been framed against that. She submits that the entire allegation is against co-accused, with whom the victim had gone, and only allegation against the petitioner is that the victim had stayed for one night in the house of the petitioner and had used her phone. The learned counsel for the state has opposed the prayer for bail. However, the aforesaid submissions are not in dispute. He submits that the petitioner was ultimately recovered from the house of the victim was ultimately recovered from the house of the petitioner. Upon call received from the mobile of the petitioner.
Call receiver, track the police.
That's true. After hearing the learned counsel for the parties and upon going through the statement of the victim recorded under section 183 BNSS, the petitioner has stated that she had left the home with the co-accused voluntarily, and then for one night she stayed in the house of the petitioner and used the phone of the petitioner. Considering the fact that the charge sheet has already been submitted, the charge has already been framed, and the petitioner has no criminal antecedent, the petitioner is eligible. Charge not framed. Charge sheet has been submitted. The petition is eligible to be enlarged.
Item 28, BA 316/5 of 2026.
In this case, 183 statement of the victim girl will be varied.
It is there. It is there.
164.
183 BNSS statement is here. You want to read it?
183.
पढ़िए, साथ में पढ़ लीजिए. आप भी देख लेते ना, इन्फॉर्मेंट के साथ में देख लेते. आप इन्फॉर्मेंट हैं, साथ में देख लीजिए 183 का स्टेटमेंट. देन आई विल.
The main important piece is not the age of the girl is 13 years.
नहीं.
The statement may be and the medical report.
क्या बोल रहे हैं सर?
मेरा कहना है कि थोड़ा मेडिकल एग्जामिनेशन रिपोर्ट जो है लड़की का और असेसमेंट ऑफ एज सब कुछ है, उसको टारगेट देंगे लास्ट. Why I am hesitating, brother, you understand? It will be not palatable to read out loud. The honorable court will have the assessment of it. It's 15 to 16 years. No sign of any recent violation of physical and sexual violation. And 164 it is occurring. Now this section is also very important, under which the charge sheet has been submitted. Procuration of minor death. I am reading out that section.
Under which section charge sheet has been submitted?
96.
96.
Whoever by means of.
That's right. The case was instituted under 96, but under which section charge sheet has been submitted?
96. जो हमारे पास कॉपी है
चार्ज शीट बताइए केस तो रजिस्टर हुआ 96 में चार्ज शीट किसमें
हाँ ये अतः वरीय पदाधिकारी के विचार विमर्श के बाद अभियुक्त नीरज पासवान उम्र 28 वर्ष पेशेवर संचन के विरुद्ध धारा 96 बीएनएस के अंतर्गत आरोप पत्र संख्या संचन समर्पित करता हूँ। That is what I was submitting.
That's all. All good.
Petitioner having criminal incident. Case alleged.
एक का जजमेंट एनेक्स कर दिया है।
Two case in note. One Malika PS case number 5320 under section 343 41 307. Another note 108 for Malika PS 342 385 387 17 of CLA.
Heard the learned counsel submitting on behalf of the parties. The learned counsel for the petitioner submits that the petition has been falsely implicated in this case, and it is alleged that it is alleged that the petitioner had taken away the daughter of the informant. He has further submitted that the charge sheet has been submitted only under section 96 of BNSS, and charge has not been framed so far. The learned counsel for the petitioner has referred to the statement of the victim recorded under section 183 BNSS, which has been received from the concerned court. And has submitted that the victim had herself gone with the petitioner. He has then referred to the medical examination report of the victim and has submitted that as per medical examination report, the age of the victim was found to be 15 to 16 years and there was no sign of recent sexual activity.
I have referred to the age by
yes.
to give permission because there is always 2 years marginal error.
The learned counsel has also submitted that there is always a benefit of marginal error to the extent of 2 years, and therefore it can be taken that the victim was around 18 years old.
Not the medical birth certificate of the victim is there. Birth certificate.
और एक मेरे ब्रदर ने कहा कि एंटीसीडेंट है सप्लीमेंट्री एफिडेविट में हमने फाइल किया
बर्थ सर्टिफिकेट में क्या है
जजमेंट ऑफ एक्विटल इन दैट केस at page 21 annex 2 is the judgment of acquittal.
26 2 12 The learned counsel for the opposite party has informant and the state have opposed the prayer for bail and they submitted that as per the birth certificate of the victim, she was 13 years of age. The learned counsels have also submitted that the victim in a statement recorded under section 183 has also alleged that the petitioner had established physical relationship with her and she was kept in a hotel. He has further submitted that the petitioner has 2 criminal antecedents, to which the counsel for the petitioner has referred to supplementary affidavits and has submitted that in one of the cases he has been acquitted. After hearing the learned counsel for the parties and upon going through the statement of the victim recorded under section 183 BNSS, wherein she has alleged that the victim was taken away by the petitioner and was the victim had gone with the petitioner and then she stayed in hotel at Ranchi and then in Jalandhar, and that in Ranchi the petitioner had established physical relationship with the victim. This court is not inclined to enlarge the petitioner on bail. ये counter affidavit आप फाइल की? Counter affidavit filed by the state is taken.
Item 29, PA 3173 of 2026.
Please, Your Lordship. Your Lordship, major offence under section 307 of IPC, Your Lordship. Earlier in this case, Your Lordship, case diary was called for, Your Lordship. Although injuries, nature of injuries, Your Lordship, grievous in nature. But Your Lordship, dispute is regarding civil dispute with respect to Your Lordship, Khata number 21, lot number 295. Custody is Your Lordship 2011-2025, Your Lordship. Charge has already been framed, Your Lordship. No, I have no any criminal antecedent, Your Lordship.
इंजुरी क्या चीज से हुआ?
इंजुरी Your Lordship जो है Your Lordship आया कि रड से मारा है, तो Your Lordship सिंगल ब्लो है, कोई रिपीटेड ब्लो नहीं हुआ Your Lordship. इसमें जो और भी कोई कुछ पर्सन थे, सबको आए थे, सबको मारपीट किए थे Your Lordship. इसी पे जो ही था. और कोई किसको बोलते हैं तलवार से चलाए थे, इसमें Your Lordship जो धरी होता है, वो तलवार से के जो वकील मारता रड से किए थे Your Lordship. No antecedent Your Lordship plan में ऑपरेट करने में बैठे हैं. Your Lordship जो at the time of medical examination में भी जो Your Lordship ग्लूकोमा स्केल जो आया Your Lordship 15 out of 15 उस टाइम Your Lordship ये fully conscious थे, ऐसा ही नहीं था कि वो नॉर्मल थे Your Lordship.
FIR तो 2020 का है आपका?
नहीं Your Lordship, उसमें जो Your Lordship जो नोटिस हमको Your Lordship इशू हुआ था Your Lordship 21/6/2024 में नोटिस करता है Your Lordship. 21/6/2024 को हमको नोटिस इशू हुआ था Your Lordship 41 लिखा. उसके बाद जो है Your Lordship हम एंटीसिपेटरी बेल फाइल किए थे.
What do you say? State.
One criminal antecedent इनका है, पैरा 169 की केस डायरी में आया है.
क्या सेक्शन में?
ये 341, 323, 324, 504, 506, 34 of IPC and 35 of SC/ST Act.
आपका इसमें बेल हो गया?
नहीं Your Lordship, इंस्ट्रक्शंस में नहीं है Your Lordship. फिर सप्लीमेंट्री फाइल कर देंगे Your Lordship.
सप्लीमेंट्री क्या फाइल करना है आपका? एंटीसीडेंट तो है.
पैरा 169 of the case.
FIR पढ़िए, इनका नाम बताइए कहाँ?
जमीन मुझे
अप्रोच खाता नंबर 2.5 इसमें अप्रोच पेमेंट वर्तीबन को भारतीय विस्तार में दाखिलदार दिनांक 23/9/2020 को ग्राम विलायत जिला गिरिडीह महेश्वर माथुर लालू यादव वासु यादव हरी
दिवाली में तो का वो इंजुरी रिपोर्ट कहाँ पे हुई इंजुरी?
Previous equation. Connection.
Or the learning council agreement on behalf of the parties. Just a minute. The learning council for the petition submits that though the petition is named in the FIR and is alleged to have caused grievous injury on the victim, but he has been falsely implicated on account of land dispute. He has submitted that the petitioner is in custody since 2011-2025 and has no criminal antecedent. The learned counsel for the state has opposed the prayer and has submitted that so far as the petitioner is concerned, there is a specific allegation that he had assaulted the victim by rod, and this allegation matches with the injury report, which was found to be grievous in nature. He has submitted that the petitioner has one criminal antecedent as recorded in para 169 of the case diary. To which the counsel for the petitioner has submitted that the padvicar is unaware about the criminal antecedent. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner in the FIR itself, causing grievous injury to the victim and the petitioner having criminal antecedent, this court is not inclined to endorse the petitioner.
Item 30, DA.06.05.2026 of 2026, along with 31.
There is recovery of one mobile, one SIM.
Item 30.
Yeah, 31 there is no recovery.
Just a minute. One mobile,
One SIM and a Royal Enfield from the place of motorcycle, but from the place of occurrence which belongs to the brother of the petitioner.
मोटरसाइकिल से क्या लेना है?
पता है कि वहाँ पर मोटरसाइकिल ये भी सीज किए हैं। Lord, and prisoner is in custody since 23/11/2025.
Antecedent.
No criminal antecedent. I have given para 15.
Victim.
Victim. Lord, there is no statement of victim. Lord, it is said that there is some transaction from the mobile. Lord, acknowledgement number is given.
No victim as such has been identified.
No, identified even. Lord,
Acknowledgement number है तो कोई तो victim है ही ना.
One more thing is there.
लेकिन no FIR institute.
No, nothing has come. Lord, as per from the case.
This what you say?
What if in technical verification 3 complaint against the sealed mobile phone?
Any FIR institute?
That is not discovered.
बाकी सब सही है.
Statement victim recording.
Heard the learned counsel appearing on behalf of the parties, the counsel for the petitioner submits that the petitioner is in custody since 23/11/2025, having no criminal antecedent, and one mobile, one SIM is alleged to have been recovered from the possession of the petitioner. He has also submitted that a statement of none of the victim has been recorded so far. The counsel for the state, while opposing the prayer, does not dispute the opposite submission. However, he submits that in the online portal, 3 complaints have been found. But as per the case diary, no FIR has been reached apart from the present. After hearing the learned counsel for the parties and considering the custody of the petitioner since 23/11/25, having no criminal antecedent, charge sheet having been submitted, ऊपर लिखिएगा charge sheet has been submitted. The petitioner is directed to be enlarged.
The next case, there is nothing has been seized. He was present along with the co-accused.
Next case is BA 3185.
Nothing has been recovered.
Just a moment. 3185 is no recovery.
No recovery. Custody is same date 23/11.
23/11.
No criminal antecedent I have stated.
How is it no recovery? Still you are.
He was present there, therefore he has been made accused.
Yes, madam.
This is not recovery, so that has been telling me तलाशी लेने पे पहने हुए कपड़े के अलावा कुछ भी नहीं पाया।
तो एक बार क्यों क्यों बना दिए?
बट वही झाड़ी के पास से काला रंग का वार्ड इंडिकेट बुलेट बाइक रजिस्ट्रेशन और उस तरह से रिकवर हुआ।
चोरी का था क्या?
नहीं, मेरे भाई का है, उसके भाई का था।
इतना आप तंग कर सकते हैं किसी को? BA number 3185 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that there is no recovery from the petitioner so far as commission of any cybercrime is concerned. He has submitted that a mobile has been seized and the same belongs to the brother of the petitioner.
No, mobile has been seized from
mobile नहीं, motorcycle has been seized,
motorcycles.
which belongs to the brother of the
No, that motorcycle belongs to earlier co-accused का जिसका बेल दिया उनका motorcycle. मेरा कुछ नहीं recovery हुआ.
Nothing has been recovered from the possession of the petitioner.
रिकवरी नहीं हुआ मेरा, बट दैट हैज बीन टेकन द केस स्टडी कि ये लोग साथ मिलकर सुशासन स्थान झाड़ी के पास एकजुट होकर साइबर ठगी का काम करने कर रहे थे।
चोर के साथ रहने वाला चोर छूत का बीमारी है क्या? चोर के साथ रहने वाले के साथ कोई खड़ा हो जाए तो उसको चोर डिक्लेयर कर देंगे? हाँ, एक आदमी को पकड़ने में 10 आदमी को पकड़ लेंगे तो सब चोर। ऐसा कौन सा लॉजिक? He has submitted that he is in custody since 23/11/2025, having no criminal antecedent. The learned counsel for the state has opposed the prayer. However, the reported submissions are not in dispute. She submits that the petitioner was caught along with the co-accused. After hearing the learned counsel for the parties and considering the fact that petitioner has no criminal antecedent and charge sheet has already been submitted, he is in custody since 23/11/2025. The petitioner is addicted to bail.
Item 32, BA 3190/2026, along with item 33, and pass over this item 1 and 2.
32 में पेज 57 देखा।
32 is 3190.
Pilot 32 में दो petitioner हैं। इमरान एंड सिराज।
ठीक है,
इमरान के पास
एक सेकंड एक एक करके देखते हैं।
एक चीज हम 57 पैराग्राफ
ये
मैं कोर्ट का पैराग्राफ देखा।
अच्छा ये है
कोर्ट का पैराग्राफ 57 देखा।
वो
नहीं, दोनों के साथ कैसे डिफर किया जाता है?
ऊपर डायरी चेंजिंग का कहना है कि डायरी
57 पैराग्राफ को देखा इसका 57
कैसे
उनका कहना है कि डायरी में चेंजिंग आ रहा है।
फिर 57 पैराग्राफ उसके बाद ऑनवर्ड पैराग्राफ भी है ब्लैक से जो पेज किया।
क्या फर्क है?
डिफरेंस
देख ले। क्या फर्क है?
वो है कि वासुदेव विक्टिम है और जो एक्यूज है वासुदेव दास वो विक्टिम का नाम राजा सेम है।
ये रिमांड आवश्यक कार्रवाई ये है वादी प्रदीप पात्रा और उसके आगे है वादी पीके मैथ्यू इसके बाद वासुदेव दास।
और अब अपना जो कोड को प्रोवाइड किया उसको वासुदेव के पास उसका नेक्स्ट पैराग्राफ में भी सेम है, लगातार 4 पैराग्राफ।
अभियुक्त सिराज अंसारी, इसमें सिराज अंसारी ये वासुदेव दास।
ये सारे केसेस पे क्रिमिनल एंटीसीडेंट का हम लेटर लिखते हैं। अब देखा ये आप काउंटर बना के रखे हैं, फाइल नहीं की है कि कैसे दिया जा रहा है, फ्रेंड जाके पढ़ा जा रहा है।
हमको काउंटर रजिस्टर हुआ है, कोई पढ़ने लायक नहीं
देखा जाए जो मोड़े हैं उसमें देखा जा रहा है। पिटिशनर के अगेंस्ट एफआईआर है और चार्ट में एफआईआर दिया हुआ है।
टोटल लिंकेज कंप्लेंट्स है 155, एफआईआर से 38।
एफआईआर का भी चार्ट देखा जाए, एफआईआर में 38 एफआईआर से।
और डायरी में कुछ नहीं,
डायरी में कुछ नहीं है। जो क्रिमिनल एंटीसीडेंट स्पेसिफिक रिपोर्ट मंगाते हैं कि इस कांड के अलावा है या नहीं, जो लिखते हैं there is no criminal antecedent provided by that. इसी आयोग का नेक्स्ट केस है जो कोर्ट में डायरी है। नेक्स्ट केस जो हम पास ओवर कराए थे इसका पारा देखा जाए 53 सुपरविजन का पारा।
अब जो
सुपरविजन का जो डायरेक्शन है
हाँ,
वही है ना,
हाँ,
उसमें फर्स्ट कॉलम दिया गया है कि इसका आपराधिक जांच करके डायरी है, बट दैट हैज नॉट बीन इंक्वायरी एंड चार्जशीट हैज बीन सबमिटेड। एंड कोर्ट को जो दिया गया है, कोर्ट से भी जाता है कि सीबी एंड क्रिमिनल एंटीसीडेंट प्रोवाइड कीजिए, बट इन दिस केस क्रिमिनल एंटीसीडेंट इज नॉट सेड बाय द आयोग। और मेरे पास इवन आफ्टर माय सेवरल कॉरेस्पोंडेंस सीबी हैज नॉट सेम आयोग, दोनों के आयोग एक ही हैं, चंद्रमणि भारती। आई हैव ऑलरेडी written the letters lordship describing everything.
किस डायरी ऐसे कैसे बदलता है?
मुझे वहाँ पहले पाइए का नियम चलता है साइबर में, जो अब हम बताते हैं अब इनको भी मालूम हो गया है।
हमारे साथ
इनोसेंट पर्सन जो होता है ना मैडम, उनको नहीं उसको नहीं पकड़ा जाता, जो क्रिमिनल होता है, जो क्राइम करता है उसको नहीं पकड़ा जाता है, उसको रास्ता में छोड़ दिया जाता है उसका अपना भाई पैसा देके। और जो इनोसेंट रहता है बेचारा पानी पिलाता है, चाय पिलाता है, जैसे अभी इनका केस में था कोई रिकवरी नहीं हुआ, वो लोग को पकड़ के चार्जशीट दे दिया जाता है कि भाई आप एक्यूज हो गए। यही तो हो रहा है वेब साइबर में। जो घर से पकड़ा जाता है और घर के आदमी को चार्जशीट में विटनेस नहीं बनाया जाता है, विटनेस पुलिस बनाएगा। जितना एफआईआर आप देखिएगा सब में पुलिस विटनेस रहता है, चार्जशीटेड विटनेस, नॉट ए सिंगल विलेजर।
हम ये इंफॉर्मेशन लेना चाहते हैं कि एक्चुअली हम लोग भी जो आर्गुमेंट करते हैं रिलाइड अपॉन दोज डॉक्यूमेंट्स प्रोवाइडेड बाय द पुलिस स्टेशन, और हमारे एक कलीग फ्रेंड को भी डायरी प्रोवाइड किया गया। इनको जो प्रोवाइड कराया गया है वो करेक्ट करके प्रोवाइड कराया गया। सब्सिक्वेंट जो हमारे बात प्रोवाइड सिराज का when I have disclosed everything, the page has been changed.
सिराज नहीं,
नेक्स्ट जो सिराज के से उसको उनको प्रोवाइड किया। अब कंटिन्यूएशन में देखा लो कि ये तो पैराग्राफ
सकील वाला में आया है, सकील का मतलब सिराज में सकील आंसर नहीं आया, सिराज पर ही आया है। सकील का केस नंबर
तो हम इसमें से कौन सा डायरी
पर यही तरह का
हम कौन सा डायरी पढ़ेंगे?
एसपी को बुलाया जाए, पूछा जाएगा इसे कैसे हो रहा है, थाना इंचार्ज
कहाँ पे है
ये सब साइबर में है, सब धारा में होता है। वैसे केस में होता है जिसमें ह्यूज अमाउंट, जिसमें 10,000 20,000 रहेगा ना, उसका डायरी एकदम परफेक्ट है। जिसमें बड़ा अमाउंट रहेगा, इस केस में बड़ा अमाउंट है, जैसे 4 लाख रुपया, 1,96,000 रुपया, 4,20,000 दिया, 1,35,000
9 लाख रुपए 1 लाख रुपए
उसमें डायरेक्शन हुआ है कि क्रिमिनल अदर केस में जो दिख रहा है कि स्पेसिफिक डायरेक्शन है सुपरविजन में कि आप क्रिमिनल एंटीसीडेंट रिपोर्ट दीजिए। मेरा नोटिस भी है कि क्रिमिनल एंटीसीडेंट कोर्ट का भी लेटर गया है, कोर्ट में आ गया विदाउट क्रिमिनल एंटीसीडेंट रिपोर्ट आ गया डायरी लॉर्ड से।
कैश रिकवरी होगा तो कैश के बारे में डिटेल नहीं किया जाएगा।
ये कितने केसेस हैं एक साथ? हाउ मेनी केसेस आर देयर?
4 केस तो अभी
ये तो आप नोटिस करते जा रहे हैं, अभी वॉच करते जा रहे हैं, हो सकता है सीरीज जो मिल जाए। इस केस को सिंपली एडजॉर्न किया गया और ऑलरेडी आई हैव रोट द लेटर टू एसपी आल्सो। व्हाट इज
एसपी को बुलाते हैं ना, he has to be there with the IU. Why such mismatch is there in the case diary which is received from the court and which is received from the APP? There is mismatch and he should come here with the original case diary.
Charge sheet has already been submitted. It is deposited.
कोई बात नहीं, चार्ज शीट हो गया है, कोई जान थोड़े किसी का चला गया।
वहाँ पर जमा भी कर दिया है डायरी, वहाँ कोर्ट में अलग जमा किया
हो जाता है ना, अब कोर्ट में उसके बाद
3-4 तरह का
कोर्ट में
डायरी
भी तो फोटोकॉपी ही जाता होगा डायरी।
नहीं ओरिजिनल एक
3 सेट बनता है, सिर्फ एक सेट थाने में रहता है, एक सेट डीएसपी लोग का ऑफिस हायर ऑफिसर होता है उसमें रहता है और एक कोर्ट
ओरिजिनल कोर्ट में
वही मंगाते हैं।
कोर्ट से ही ओरिजिनल मंगाया जाता है,
कोर्ट से मंगाते हैं और उसके अलावा आपके पास जो कॉपी है वो भी लेके आएंगे, ठीक है?
और जो सब्सिक्वेंट किया जा रहा है लॉर्डशिप को राजा ने कोर्ट में सबमिट किया गया, तो कंटिन्यूएशन है, देखिए कैसे स्केच करके उसको बाद में लगाया गया, कंटिन्यूएशन पे
ऐसा हम बहुत केस में देखे हैं। दिस इज नॉट द ओनली केस। अगर एक भी केस में अगर ऐसा इसके बेसिस पर अगर मान लीजिए किसी को बेल हुआ है, आप कैंसिलेशन हम कैंसिल कर देंगे। आई विल इमीडिएटली कैंसिल द बेल। जहां आपके पास आ जाएगा कि इनका एंटीसीडेंट है और इस तरह के केस डायरी के बेसिस पर ये ऑर्डर हुआ है, यू फाइल कैंसिलेशन, आई विल कैंसिल द बेल, दैट इज रिक्वायर्ड।
सबको घर से पकड़ा जाता है, सबको दिखाया जाएगा, स्पोर्ट पर दौड़ा के दूसरा दिन पे एफआईआर किया जाता है।
सब कुछ हो रहा है लेकिन साइबर ऑफेंस तो हो रहा है ना।
साइबर हो रहा है, साइबर जो हो रहा है, साइबर जो हो रहा है ना, जो
क्यों हो रहा है, साइबर क्यों नहीं हो रहा है, इसको हम हाईलाइट करना।
साइबर में जो हो रहा है,
हाउ इन्वेस्टिगेशन ऑफ डेयर टू फाइल दिस डॉक्यूमेंट्स बिफोर द कोर्ट।
यस,
जो कर रहा है वो ये पकड़ा जा रहा है।
सबमिट द डॉक्यूमेंट बिफोर मी।
बड़ा मछली कहीं नहीं,
बड़ा मछली कभी नहीं पकड़ा है, आज तक नहीं पकड़ा है। ये सब पानी पिलाने वाला, चाय पिलाने वाला ये सब पकड़ाता है। खाली दिखाना है कि इतना साइबर को हम पकड़ लिए, लेकिन ओरिजिनल नहीं पकड़ा।
And to avoid multiplicity of the FIR, what they are apprehending from different places and they are showing that we have apprehended wrong person from one place.
लिखिए तो in PA number 3428 of 2026. एक सेकंड, अभी किसी को बेल नहीं हो सकता, आप एकदम भूल ही जाइए।
नहीं हम दूसरा बात बोल रहे हैं, जो सिंगल 10 जो पास ओवर हुआ था, जो अभी ये बात है, उसमें सिर्फ एंटीसीडेंट नहीं दिया गया था, उसका अलग से मंगा के उसमें डिफरेंस नहीं है।
एसपी को बुलाते हैं।
नहीं ये एफआईआर से नहीं है, वो डिफरेंट केस है।
सेम आईओ है हमारे कहने का सेम आईओ है। हाउ ही
नहीं हम वो नहीं बोल रहे, जो सिंगल 10 जो पास ओवर हुआ था, रेजिंग आउट ऑफ डिफरेंट उसको अलग से सुन लिया।
नहीं सेम आईओ है, अलग से क्या सुनेंगे?
आईओ सेम है,
काफी है ना, उसका कंडक्ट आप देख रहे हैं।
हाँ
तो फिर इट इज इन वेरी सीरियस क्राउड, ऐसे नहीं करेंगे। ये आपने केस डायरी प्रोड्यूस किया है ना,
ये जो दूसरे एपी इसको प्रोवाइड किया गया, ये हम जो प्रोवाइड किया गया उसको दिए हैं और से और कोर्ट में एक आया है।
एक तो ये है जो आपने प्रोवाइड किया है, एक कोर्ट का है शायद ये
कोर्ट का शायद
4 of 26 है ना, 4 of 26 नहीं 4 of 26 अलग,
9 of 26
4 अलग है, 4 अलग वाले,
4 अलग है,
ये 9 है,
इसको अलग
4 है
9 of 26।
लॉर्डशिप के पास दिया गया जैसे कंटीन्यूएशन अगर कोई टाइप होगा, कंटीन्यूएशन अगर फोटो स्टेट होगा,
ये
4 अलग है,
4 अलग। There is a mismatch in para number 59 and
57 onwards up to the
57 onwards.
up to the 61. इसको कट टेस्ट में भी गलती से आना का नहीं माना जाएगा, क्या है कि विक्टिम्स का नाम ऊपर सेम है, अमाउंट सेम है, सारा चीज है। अगर कोई दूसरे डायरी टाइप से कॉपी करके पेस्ट भी करेंगे।
The learned counsel for the state, Mr. Sailin Tiwari, has pointed out that there is serious mismatch in the case diary which has been received by the court in connection with cyber case number 9 of 2026. And the case diary received by him. He has in particular referred to page 56 and paragraph 57 to 63 of the case diary. The learned counsel has submitted that the name of the accused has been completely changed and other details have remained the same. He has submitted that apparently this has been done to give some benefit to the accused with respect to identification of the victims in commission of the cyber offence. He has submitted that
even after notice he has not submitted the criminal antecedent report. So the criminal antecedent report that is failed and not clear.
the learned counsel has submitted that in spite of due communication, the criminal antecedent report of the accused has not been provided and whatever has been provided is absolutely faint. In view of the aforesaid mismatch which has been pointed out, he has also submitted that so far as the mismatch is concerned, it contains some scanned copy and rest of the case diary is absolutely clear and the scanned copy is blackish. ये दोनों को ना स्कैन कर देंगे, ये पेज नंबर 56 एंड 57 इसका एंड 56 एंड 57 इसका, इसको स्कैन करना है ना, ऑर्डर मिला। In view of the aforesaid, it has been submitted that there is serious irregularity in the matter of investigation / preparation of case diary and whatever is being submitted before the court and the records which are available with the investigating officer. आयु का नाम पता है?
या चंद्रमणि भारती.
He submits that one Chandramani Bharti is the investigating officer of the case. The case arises from Jharkhand. In view of the aforesaid, this court is of the view that the SP of the concerned district should appear before this court, SP of Jamtara should appear before this court personally along with the investigating officer of the case with his explanation with respect to the aforesaid discrepancy as has been projected in the embossed portion in this one. ये पूरा emboss ही कर देते हैं, अपने बताएंगे.
Another case of point of view is same. Even after supervision and
the SP is directed to remain personally present along with the IU on next Wednesday at 10:30 a.m.
एक और चीज
एक रिक्वेस्ट हो
This order be also communicated to the Director Prosecution so that he shall also remain present. He shall also remain present.
One more request, let the case diary originally submitted in the court below be called for from the court. That will also pass the everything.
मैं भी सबमिट किया हूँ
वहाँ कोर्ट में सबमिट किया हूँ।
वहीं से ना स्कैन होके आ रहा है।
वही नहीं कोर्ट से तो नहीं आ रहा है।
कोर्ट से थाना से
नहीं, हम जो केस डायरी मंगाते हैं
थाना से आ रहा है।
हाँ, ये थाना से आता है।
थाना से आ रहा है, इसलिए कोर्ट में जो सबमिट है उसको भी मंगाया।
इसको मंगा दिया था
सारा
हम तो कोर्ट से मंगाते हैं तो यहाँ पे थाना से क्यों चले आए? हम तो हमेशा लिखते हैं फ्रॉम द कंसर्न कोर्ट। मेरे ऑर्डर में हमेशा रहता है कि केस डायरी भी कॉल फॉर फ्रॉम द कंसर्न कोर्ट। आई नेवर राइट, क्योंकि एक बार चार्जशीट हो जाने के बाद तो हम कोर्ट से ही मंगाते हैं।
चार्जशीट नहीं होता
इसमें चार्जशीट हो गया।
इसमें चार्जशीट हो चुका है। It has been reported that charge sheet has already been submitted. The office is directed to call for a scanned copy of the case diary from the court concerned. The registrar of the court shall take special care to ensure that the exact copy of the case diary as submitted in the court is forwarded to this court. वहाँ से आ जाएगा स्कैन।
एक चीज और मैम, स्पेशल पीपी जब साइबर के एक ही है तो एक ही स्पेशल पीपी को साइबर मिलेगा तो ताकि देखने में भी सब ठीक लगेगा।
देखिए ये सारी चीजें जो है ना, आपको ऐसा बात नहीं है, हमें पीपी से कोई मतलब नहीं। ये चीज, ये जो इस तरह का बेंच का कॉन्स्टिट्यूशन एंड सब्जेक्ट वाइज जो एलोकेशन है, इट हैज अ पर्पस। क्योंकि एक केस डायरी कहीं जाता है, दूसरा कहीं जाता है, तो कोर्ट के नजर में नहीं रहता है कि क्या हो रहा है।
एक ही जगह पे स्पेशल
एक्चुअली पता क्या है ना कि लॉर्ड की हम लोग से भी मिस्टेक होता है, लेकिन मिस्टेक अलग कैटेगरी में होता है।
नहीं, मिस्टेक अलग चीज है और
अलग चीज होता है, लेकिन
इस तरह की चीजें नजर में आएगी तो आप लोग को तो बताना ही है ना।
नहीं, हम फोन भी किए, कम्युनिकेट भी किए, देर आफ्टर कोई रिस्पॉन्स नहीं आ रहा है।
थोड़ा आपको ये हम दे देंगे सेकंड हाफ में, ऑर्डर भी अपलोड हो ही जाएगा, ठीक है। इसको हम रख लें।
इसमें भी ऑर्डर कर दिया जाएगा।
किसमें? एक दूसरा केस में बताइए।
दूसरा केस में
क्या मिसमैच है?
उसमें मिसमैच नहीं, सेम आईओ का है, कि चंद्रमणि भारती का सुपरविजन रिपोर्ट में डायरेक्शन हुआ था कि क्रिमिनल एंटीसीडेंट पता करके लिखी है, लेकिन उन्होंने ड्यूरिंग इन्वेस्टिगेशन उस चीज को नहीं पॉइंट आउट किया।
इसमें सब बेल हो गया कि नहीं है, अगर मंगा लिया जाए इसमें,
कुछ नहीं मंगानी।
ये है टाइम
इसमें मिसमैच नहीं है, इसलिए बोले
कोई बात नहीं, मिसमैच नहीं है, थोड़ा दिन जेल में रहिए, कोई बात नहीं।
ठीक।
इन बीए नंबर ये किसमें होगा? सिर्फ एक ही केस में ऑर्डर है कि इसमें और
एक केस में था 32, ये आइटम 10 है, सिर्फ सेम का है। इनको हमको क्रिमिनल एंटीसीडेंट केस में मांगा गया, सुपरविजन रिपोर्ट जो किया गया उनके डीएसपी के द्वारा कहा गया कि इस अपराधी का क्रिमिनल एंटीसीडेंट पता करके डायरी में लिखी है, बट ही हैज नॉट मेंशन्ड अबाउट द क्रिमिनल एंटीसीडेंट रिपोर्ट, neither he sent the criminal antecedent report to me or neither court में डायरी सबमिट किया उसमें भी
नंबर 2452 of 2026. The learned counsel for the state has pointed out that as per the case diary there is a supervision report requirement, supervision note to trace the criminal antecedent of the accused persons. He submits that neither the criminal antecedent has been recorded in the case diary nor the same has been forwarded to the concerned agent. He submits that under such circumstances, he is unable to properly assist this court on the point of criminal antecedent. The matter in serial number 32, the concerned IO has already been directed to remain present on next Wednesday. Let this case be also placed on next Wednesday. And the IU is directed to file a show cause as to why the criminal antecedent report has neither been recorded in the case diary nor forwarded to the concerned AP. Non-furnishing of such report hinders the due adjudication of the cases before this court. हो गया ये दोनों केस, और बाकी दोनों
सारा उसी में है, वो अलग है, ये सिर्फ अलग है।
33 भी टैग है मैडम, 33 भी also टैग में
ये वाला हटाइए इसको।
33 है
ये आपका है,
हाँ वो मेरा है, हम सबमिट नहीं कर पाए थे, काउंटर एफिडेविट बना हुआ था।
3190
यस।
Next one is
और 3428
वही 32 के साथ
ये 32 के साथ along with him, ठीक है। और बताइए अच्छा, सीरियल नंबर 1 जो है
3876
सीरियल नंबर 1 with 32 with 33 they arise out of the same FIR, right? इसीलिए ये तीनों में ये कॉमन ऑर्डर होगा जिसमें एम्बॉस करना है आपको and post on next Wednesday to be taken up as first case at 10.
one of the supplementary
हाँ one of supplementary और कोई बच्चा
टैग कर देंगे।
अगर किसी का भी एंटीसीडेंट आ जाए और आपको पता चले कि डायरी के किसी भी चीज़ को देख के आपने कोई सबमिशन किया है, आप कैंसिलेशन फाइल करेंगे, आप तुरंत नोटिस करके कैंसिल करेंगे। बिकॉज आई हैव रिकॉर्डेड इन एवरी ऑर्डर हैविंग नो क्रिमिनल एंटीसीडेंट, दैट इज द कंसिडरेशन। आपका सबमिशन में नहीं लिखा है, मेरा फाइंडिंग में लिखा है, आई मेक इट पर्पसली वेरी वेरी क्लियर। कुछ केस में तो हम लिखते हैं कि वहीं पर वेरीफाई कर लेने के लिए, सो दैट इज इम्पोर्टेंट।
नहीं, it is so open available कि if bail granted
नहीं
हो तो suppression of different।
नहीं, कभी कभी क्या होता है कि सबमिशन में बोले लेकिन कोर्ट ने सिर्फ कस्टडी के ग्राउंड पे बेल, तो कोर्ट का जो एप्रिसिएशन है वो सिर्फ कस्टडी पर है, irrespective of whatever it is. But if the court is saying that because he is having no criminal antecedent and custody है, तो the situation is different. इसको मैं रख रही हूँ आपको, ये वाला नहीं, ये तो केस डायरी है, एक सेकंड, ये केस डायरी है और ये है, अब ये आपको लगेगा, ये मैं रखूँ, ये फाइल कर दीजिए, ये आपका फाइल है ना। और कितना यही बच गया, सेकेंड आपको करते हैं 5 मिला, ये कर लेंगे अभी। अच्छा हाँ, कॉल तो होने दीजिए।
Item 34 DA3324 of 2026.
This diary was one for that has been submitted or counter has already been filed by this state.
क्या करना है? काउंटर क्या दीजिएगा? केस डायरी आया हुआ है, इसके अलावा क्या काउंटर? हाँ? Counsel for the informant is present. He prays for some time to file a counter affidavit in this case. Counsel for the petitioner undertakes to provide a copy of the bail application with its enclosure to the counsel for the informant during the course of the day. Post this case on Tuesday in the supplementary cause list. Counter affidavit, if any, should be filed by Monday. इससे ज़्यादा टाइम नहीं दे सकते हैं। ये आपका काउंटर है। Counter of the state is taken on.
Item 35 DA3343 of 2026.
फाइल कर दिया गया है, उसमें रिपोर्ट भी फाइल कर दी है, 10 गवाही था, 4 हो चुका है और एफिडेविट करके हमने फाइल किया है कि सबको नोटिस भी किया है, 19/5 को इंटेक्ट रखा गया है सबसे एविडेंस 10/5
आपका अर्लियर रिजेक्टेड है? कितना हो गया है?
4 हो चुका है।
Out of 10.
Yes.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the bail application of the petitioner was rejected earlier on 18/12/2024 and then on 1/8/2024 in BA number 10706 of 24 and then in BA number 5119 of 25 and he has renewed the prayer for bail on account of custody. The petitioner is in custody since
8/7/2023.
8/7/2023. 2023. The learned counsel for the state has opposed the prayer and has submitted that there is serious allegation against the petitioner. उनका submission रखो. There is serious allegation against the petitioner that the wife of the petitioner was found murdered in the matrimonial home, locked from outside, and the petitioner was found absconding. He has further submitted that out of 10 witnesses, 4 have already been examined, and the next date in the case is 19/5/2026. He has also submitted that the state shall ensure that the witnesses are promptly produced so that the trial is taken to a logical end. After hearing the learned counsel for the parties and considering the serious nature of allegation against the petitioner, and the bail application of the petitioner was earlier rejected, this court is not inclined to enlarge the petitioner on bail only on account of period of custody. The fact remains that the trial is in progress, and out of 10 witnesses, 4 have already been examined, and the next date is 19/5/2026. The state is directed to ensure that the witnesses are promptly produced before the court so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to the SP of the concerned district and to the director of prosecution to ensure compliance. Time period means.
Item 36, BA 3378 of 2026.
In this case, charge sheet not been submitted, so a date will be fixed. So time period might be.
When should I post it?
After vacation, let's.
The learned counsel for the petitioner prays that the matter be posted after vacation. Post on 8th of June. In the meantime, the counsel for the state is directed to inform this court about as to whether the charge sheet has been submitted and whether the petitioner has criminal antecedents. Counter भी फाइल करना है?
काउंटर डायरेक्शन हम फाइल कर पाए रिसीव
And the counter भी फाइल.
Item 37, BA 3517 of 26 along with item 32.
रिसीव कर लेकिन फाइल इसको भी रिपोर्ट कर देना.
At the request of the counsel for the opposite party, the matter is directed to be listed on Tuesday. The counter affidavit will be filed by Monday.
Same model 38.
38 भी same. Okay.